every morning. Grateful that we all are blessed with such an opportunity. I wish everyone present here a very good morning. I, Lavanya Ayodpi, student KSLU's Law School, welcome you all to the national webinar on electoral reforms organized by the Research Center in Democracy and Constitutional Government, Karnataka State Law University, Hubballi. Welcome you all. It is our tradition to mark the beginning of any auspicious occasion with a prayer. So I call upon Ms. Pramati, student KSLU's Law School, to invoke the blessings of Lord Almighty. Please, Pramati.
प्रथम सुमर श्री गणेश गौरी सुत प्रिय महेश। प्रथम सुमर श्री गणेश गौरी सुत प्रिय महेश। भय कलेश दूर से निहारे, दूर से निहारे। प्रथम सुमर श्री गणेश पूर्ण गुण गण निधान सुर मुनि यश करत गान। ब्रह्मानंद चरण ध्यान भक्त हितकारे, भक्त हितकारे। प्रथम सुमर श्री गणेश गौरी सुत प्रिय महेश। सकल विघ्न भय कलेश दूर से निहारे, दूर से निहारे। प्रथम सुमर श्री गणेश। Thank you.
Thank you, Pramati. I now request Professor C.S. Patil, Head Research Center in Democracy and Constitutional Government, Karnataka State Law University, to welcome and introduce the revered guests of today's function. Please, sir.
Good morning, everyone. It is a privilege that is bestowed upon me to welcome the honorable dignitaries who are present here in the inaugural function. It was at the behest of the honorable Speaker of Karnataka that the Karnataka State Law University has embarked upon a series of activities in the area of electoral reforms and sensitization of electorate, and having a voter literacy club in the university, an essay competition, a debate competition, and a host of other activities. As part of that, we have organized this national webinar on electoral reforms. And when we thought of this, we felt we will involve the best of the scholars so that our students and faculty members will be benefited by the discourse and some useful information is churned out. We requested the Honorable Vice Chancellor of the Raichur University, the founder Vice Chancellor, Professor Harish Ramaswamy, a great educationist, a benevolent academician who has always encouraged students in various capacities, to inaugurate this webinar. He readily agreed. To briefly introduce Professor Harish, he hails from Mysore and he has studied in best of the schools, Sishu Vihara of Gopal Swami Sishu Vihara, then Marimalappa's High School, which is one of the very prestigious schools in Mysore. Then he went on to graduate from the prestigious Maharaja's College, Mysore, then completed his post-graduation in political science and did his PhD from the University of Mysore. When I joined my LLM, in 1986. He was a very charming young professor, and now also he is a very charming young professor we have in the academic world. He was a professor, assistant professor in the Department of Political Science, Manas Gangotri, Mysore. Always he was in the group of students. After a brief stint at Department of Political Science, Mysore University, he moved over to Karnataka University, Dharwad, wherein he served as assistant professor, associate professor, professor, and various other responsibilities he held. Had the privilege of being his colleague in the Karnataka University. He was a officer on special duty to two vice chancellors to aid and advise them in policy matters and administration of the university. He has served as chairman of the Department of Political Science. He was the director of HRDC, Human Resource Development Center of Karnataka University, wherein he trained number of faculty members. And he is the founding vice chancellor of the newly established Raichur University, and that is the onerous responsibility he has shouldered to say build an elite institution in the area which is covered under 371G of the Constitution. And a glimpse of his activities is to be given to the members present here. He has guided several PhDs, and he has always emphasized on empirical study. Wherever he was chairing the session, wherever he was chairing the paper presentation, I have seen him to be very critical and always gave useful guidance to the participants so that they can improve in their next performance. And he was always involved in electoral analysis, and his team has secured the best research team in the national election studies. And to encourage students, he had Tuesday group, what was known as Tuesday group. Tuesday used to be half day in Karnataka University those days, and afternoon of Tuesday was a very useful exercise for the Tuesday group members in the political science department, wherein youngsters were groomed to speak, analyze, develop critical aptitude. And he was also bringing out two periodicals, practice journals, to groom the political science students. So I can go on enlisting the achievements, encouraging gesture of Professor Harish Ramaswamy endlessly, but this is not the occasion. On behalf of all the statutory officers of the Karnataka State Law University, all the authorities of the university, and all the staff and students of Karnataka State Law University, I extend a very cordial welcome to Professor Harish Ramaswamy, who will be inaugurating this session. Welcome, sir.
Thank you. Thank you, sir.
Professor K.C. Sunny is one of the persons who has presented himself as a person who has gone for a very avid studies in the field of election laws and electoral reforms. And he published his first book on election laws in 1990s only. Since then, wherever electoral reforms debates go on, he is always involved as a resource person. And when we requested him to deliver a keynote address for this national webinar, he readily accepted. Professor Sunny is a great human being, and he is a very amiable character who has always encouraged youngsters. A professor with 30 years of teaching experience in Kerala University and Central University of Kerala, out of which 11 years he has served as professor, 8 years he has served as G. He is a graduate, Master of Laws with first rank in 1986, and he started his teaching career at the prestigious Kerala Law Academy and Law College at Trivandrum. Later, he joined for research with UGC Fellowship and secured his PhD. He has joined Kerala University Department of Law Karyavatam campus in 1990. He published, as I was telling, his book, Corrupt Practices in Election Law, and he has published more than 50 research papers. He has guided more than 20 students to their doctoral degrees. He was an international observer to Nepal Constituent Assembly elections in 2006 and Bangladesh Parliament election in 2007. He had delivered lectures. He has delivered lectures in 16 foreign universities and had interactive sessions in foreign universities, including Harvard Law School. He has served as program chair of the International Conference on Law and Public Policy held at Singapore for 7 years. Dr. Sunny is presently the Vice Chancellor of National University of Advanced Legal Studies, Kochi. On behalf of all the statutory authorities, officers, staff and students, and all the invitees who are present here, I extend a very cordial welcome to Professor K.C. Sunny, who will be delivering the keynote address. Welcome you, sir. And our own Vice Chancellor is a very towering academician that we have in the field of law, recognized all over India and abroad as a scholar, especially in the area of constitutional law. And we all know his achievements and the accolades that are conferred upon him. On behalf of everyone, I extend a very warm welcome to our distinguished Vice Chancellor, Professor P. Ishwar Bhatt. Welcome you, sir. I extend a cordial welcome to our Registrar, Sri Muhammad Zubair, our Registrar Evaluation, Dr. G.P. Patil, our Dean, Dr. Ratna Baramagoda, all our faculty members in ASLU's Law School, and I am seeing some distinguished personalities who are present here. A special welcome to Professor Jeevan Kumar, with whom I had the privilege of some association in RDPR University. He is such a wonderful person. I see Professor Sudesh here, Srimati B.R. Patil, various other principals. I extend a very warm welcome to everyone. Thank you very much.
Thank you, sir. I now call upon Professor Harish Ramaswamy, Vice Chancellor, Raichur University, Raichur, to address the gathering. Please, sir.
Thank you. Thank you very much. Professor Patil, thank you very much for your nice introduction. It's much more a cordial kind of an introduction that you gave. Professor Ishwar Bhatt, Vice Chancellor of Karnataka State Law University, who is also presiding today's function. Professor K.C. Sunny, whom I just came to know, is a great scholar. He is heading as a Vice Chancellor the National University of Advanced Legal Studies. And Professor Vivijay Kumar, with whom I had a brief interaction earlier and continues to be a Vice Chancellor of National Law Institute University. And Professor Jeevan Kumar, of course, my senior and has been guiding us. He's like my teacher, I can say, because Sandeep was a student, and then therefore I can always say Sandeep and I as being of the same contemporary age. Professor Jeevan could be considered as our teacher. And I also recognize the presence of Registrar Evaluation, Dean of Law University, and also many other scholars from various walks of field, and then of course from the legal education. I've been given this job to inaugurate. I don't know why Patil chose me to inaugurate when he had so many scholars. Probably he wanted me to speak on the occasion with my experience in the background, because I used to do election analysis and things like that. And when I speak about this electoral reforms, it would look a little political. That's obvious because I come from political science background. And then I also make it look political because obviously it is politics which has to decide about how the electoral reforms will have to come about. If we really are intended to bring about certain changes in our political system. As I inaugurate, I would like to sort of bring in about 5 important components to the fore, so as to let the webinar think loudly as to whether there is some kind of a reality behind the whole idea of electoral reforms. I might start with a bit of, I would say, a negative tone, because electoral reforms have been discussed for almost 3 decades now. And what is the progress? If you try to look at the progress that we have made, we have been making a snail's pace progress, and the commentaries that we have been hearing about election commission or the electoral reforms that have been brought about as ineffective has been continuously bothering us. We all agree on one thing: we need electoral reforms. But who is to bell the cat? If you go back and see, way back in 1960 itself, we started thinking in terms of electoral reforms. Probably around 1967, we started looking at the growth of regional political parties, and then the demand for electoral reforms, center-state relationships, etc. In the 1975 and 1980s, you found that the whole thing came to fore. And in 1974, committees were appointed, and the Election Commission itself had done a lot of exercise in this regard. Now, when I raise the question that we all agree that we need electoral reforms, and it is important for the health of democracy, why is it that we are not taking this issue seriously? Now, one of the problems that I see is that electoral reforms has been academically talked of quite a bit, in fact, quite a lot. But then when it comes to the question of those who matter in bringing about the electoral reforms, they themselves are not very keen on these things. Now, if you put a question as to why the electoral reforms, one of the important things that come to the fore is the faulty system, or a system that has been faltered by the participants, both the electorate and the elected. Now we hear that the political system takes opportunity to rig elections and tamper the elections, manipulate elections, and political leaders and political parties accuse each other. But what is the electorate doing? If you look at what the electorate is doing, it seems to be simply a passive observer of the whole thing. Now, it is here that I start with my worries. Because if the electorate is keeping quiet, and if we are not demanding changes, why would anybody bring about changes which suits them? Which suits to what their comforts and their comfort zones. Now look at the whole process of elections. We are very happy that the elections are taking place on a regular basis, every 5 years. But the question is, are we happy with procedural democracy? Now it seems so, because whenever I see the kind of arguments that are placed before the public by both the nations and the politicians, I see that they compare countries like Pakistan and say that a neighboring country doesn't have their elections held regularly. But my concern is not that. If you are looking at a substantive democracy where there is equality of participation, equal representation, and then there is an opportunity for everyone to participate in the election or contest the elections, we have not been able to actually realize these things. Even those who are idealists, who got into politics are today frustrated. There are a number of cases also. Perhaps Mohinder Gill versus Chief Election Commission in 1978. V.R. Krishna here spoke about the need for electoral reforms. Then the second question that we need to consider when we talk about the elections are the constituents versus the representativeness. Now, most of us are aware that elections are supposed to give us representatives who represent our interests, the interests of the constituents. But most of the time we see that it is the interest of the party that is represented or the interest of the individuals that are represented. And overall, the democracy doesn't really consider the need of the constituents. But are the constituents empowered to take any decision? We come across NOTA as one of the important components which has come into electoral reforms. But I don't know whether it has any legal sanction post your exercise of NOTA. Then there is also the question of representation and representativeness. You have Pitkin, who has studied this question of representation and representativeness. She argues that there is representation given through election, but these representations are not actually the kind of representations that are needed. Say, for example, there is a representation of women. She calls it a silent representation because they are represented, but they do not discuss. But when the constituents want their interests to be represented and when they elect these people, you find that the representativeness of these electorate, the elected leaders, is either hidden with a political party and its agenda, or they are constrained by the ideologies and they're incapable of presenting their viewpoints, personal viewpoints. So when an election happens, every time you find that the same person gets elected on whatever ground, and we are going to discuss all those things perhaps in this course of seminar, and we all know how it happens. And there are contestations whether the family or hereditary contestation should be there or not, and what should be the change that we need to bring about in order to inflict some kind of a change in these kinds of democratic methodologies. Then there is the question of participation of the people. Now, whenever we talk about the participation of the people in the democratic process, we are only looking at the representation part of it through elections. As a result, what has happened? The participation of the people in other forms, like protest movements, or trying to dismantle a system which is not actually delivering the goods that are required, are not debated at all. Now, populism has taken over a lot of these issues and the people are kept silent. And as a result, we find that the whole idea of electoral reforms keeps coming back to the discourse table, and then people start discussing about it again and again, with little change actually happening at the ground level. Now, if you look at the third aspect of it, the election commission itself, the basic question that comes to my mind is whether this institution is independent or free. I'm sure Professor Sunny will enlarge on these issues. Now, we have been seeing that election commission has been in the light of a lot of criticism right from the appointment of the election commissioners themselves, except for Sheshan, who made a difference. Not many of the election commissioners have been able to make any difference. Now, the question of whether it can be independent or free is still debatable, because we've been seeing the election commission as a group of people representing bureaucrats, representing the whole idea of the commission being independent and conducting elections, has become partisan at some points. Some people also accuse this, that the majoritarian rule is causing all these things. I do agree. But then there are also a lot of unrealistic suggestions, mystic laws. And I'm unable to understand how these things come about without practically or empirically verifying all these things. One such issue, of course, I can discuss here is the expenditure part of it. We all know that the election expenditures are outgrown. People who are given money, that is the voters' corruption, these things have actually spoiled the whole system. And even then, we find that the election commission is said to be independent, and people have been arguing that it is independent and it is doing its bit. Now, what is the alternate to election commission? Is it the question of composition? Should we change the composition? Or is it possible that we liberate the election commission from the clutches of the government so that the appointment of these election commissioners are not done by the executive? Can these people be also elected? Now, such immediate ideas will have to be thought over, because unless you liberate these institutions which conduct such huge elections, which is its success, of course, I'm worried that we may not be able to talk about electoral reforms easily. Now, from Goswami report to ARC to Vohra committee, we have a galore of suggestions. And all these suggestions have come about to give us a good reformed system. But how often do we see these things practically yielding results? Look at Anti-Defection Law. It is nothing but hoodwinking. But this also brings to the fore, to my mind, the power of speaker versus the judiciary. As a student of political science, I understand that whatever transpires in the legislature, the power of the speaker should be highlighted, and he has the power to take certain decisions. But when it is questioned in the court of law, you find that judiciary overrules the power of the speaker. This has happened in case of Mumbai, this has happened in case of Tamil Nadu, this has happened in case of Karnataka. And excepting in case of Bombay, you find that most of the cases, you find that the judicial decisions have not been as effective as it should have been. Now, if that is the case, to contain the corrupt practices of the electorate, the elected leaders or the legislators in terms of hoodwinking the defection, anti-defection laws and things like that, why not we debate on the powers of the speaker, the nitty-gritty of the powers of the speaker, and the interpretations that have come about recently? And with regard to election expenses, once again, there are a number of cases: Ramesh Dalal versus Union of India, Yedia versus Union of India, Lily Thomas case, PUCL. Most of these cases have been talking about how transparent elections should be. There are also many suggestions that we should give up this FTTP, the process that is the first past post system of the election that we conduct in India, because it does not scientifically represent the representation of the elected. Because many a time as scientific attack on democracy has taken place, that we elect a very thin margin of a leader who out of 100 has taken about 21 votes, and 80 votes have been divided, 79 votes have been divided, and because of the majority, he wins. That is not actual representation, is the argument. But what are the other alternatives? Should we be looking at a list system, or plurality of system, or proportional representation? There are a number of other methods of election which we can look at. But which is suitable to this country, which is a country which has a lot of plurality in terms of socio-cultural existence, and also there are a number of political parties which have been growing day in and out and then dying out. One suggestion that comes time and again because of the experience of the 1983 is the growth of regional political parties, during which time Sarkaria Commission was pressurized, and then Sarkaria Commission started coming out and then explaining several issues connected to the center-state relations and restructuring the whole process. Now, my thinking is electoral reforms are necessary. We need to bring about reforms, but what should be its nature and structure? How are we going to bring about? Once we bring it, are we going to see the kind of results that we have been expecting? What should be the outcome of any electoral reform? Should it improve the representativeness? Should it improve the quality of debates, policies, prescriptions that come out of the government? Should we be able to elect the right kind of people without the influence of money, muscle, etc.? We need to list out all these things, because if we do not do it, who else will do it is a question. But unfortunately, I see a passive citizenry who is not interested in these kinds of things, and an academic community which discusses these issues seriously for the sake of academics, but then there is no pressure group formed. We are not insisting that these electoral reforms should come about. Parties come to power talking about all these things, whether they are in majority or minority, but they don't really implement these things because it doesn't suit their winnability. Look at the choice of candidates. Every political party is interested in choosing a candidate who wins the election. So while we argue time and again, I think I've been seeing these kinds of arguments over 3 decades now, that we need political reforms, we need electoral reforms. But nothing is actually happening at the ground level. So therefore, I raise certain questions like, are we really serious about these electoral reforms? Do we really need them? Will this bring about any change that we are anticipating? The second concern that I raise here is, do we have a political will? Because if you do not have a political will, talking about electoral reforms becomes another academic exercise and ends up there. The third concern that I raise is, can we make the Election Commission completely independent of the governments? Because most of the time, Election Commission also depends on money, which is given by the government for its survival, because it has to conduct a huge machinery with which it has to conduct the elections. The political convenience with which the Election Commission is manipulated by the political parties will have to be really changed. The next concern that I have is, as citizens of India, are we really concerned about the representatives and their representative characters? Because ultimately the electoral reforms will have to give us a clear picture of whom are we electing and what are they going to represent. Perhaps if these things are not considered seriously, now talking about electoral reforms, as I said in the beginning itself, becomes one another exercise to be added to our leaflet of biodata saying that I participated in it, but we will not be able to make any impact. So this August gathering, I'm sure Professor Sunny will also raise much more pertinent issues regarding the electoral reforms, and a good debate will take place. I see Professor Jeevan coming up with a very interesting paper, and many of the interactions would also throw some light on how this electoral reform that we are talking about, we intend to bring about, is going to really make a difference to Indians in the Indian elections and the Indian polity in general. But if we cannot do these things, and if we do not pressurize and push these to the level of policy making, I think we will continue to fail our democracy and not blame only the politicians for that. Thank you very much. Thank you for the opportunity. Thank you once again.
Thank you, sir, for your
Thank you very much,
insightful
sir.
words. Thank you, sir. I now request Professor K.C. Sunny, Vice Chancellor, National University of Advanced Legal Studies, Kochi, to deliver the keynote address. Please, sir.
Chief guest of the occasion, Professor Dr. Girish, Vice Chancellor, Raichur University, Chairperson, Professor Dr. Ishar Phat, Vice Chancellor, KSLU, Professor C.S. Patil, Professor Jeevan Kumar, other distinguished faculty members, statutory officers, and dear friends. I am extremely happy to be the part of this national seminar on electoral reforms. At the outset, I must congratulate Karnataka State Law University and its Vice Chancellor, Professor Ishar Phat and Professor C.S. Patil for organizing this seminar, having great national importance. Unfortunately, in our education system, especially in legal education, due importance has not yet been given to election laws. Though we have more than 10 lakhs constituencies comprising of parliamentary constituencies, assembly constituencies, constituencies of or divisions of corporations, wards of panchayats, for which electoral representatives have been chosen by the people. Even today, election law is something foreign to even practicing lawyers. In this context, this seminar has great significance. My memories go back to 1993 or 93, I think, when a seminar on election law was conducted in University of Mysore under the able leadership of then Professor and Head, Professor Nagaraja and Professor Ishar Phat. I attended that seminar, and actually I got so many good friends from there, including Professor C.S. Patil, Professor Aital, Professor Shashikala Gurpur. In that seminar, I had the opportunity to hear some perspectives from political scientists. I heard the perspective of Professor Umabadi, then Professor and Head of Department of Political Science of University of Mysore. Professor Umabadi pointed out one fact that there are so many limitations to control political process by legal process. So political process is something independent. But the political process can be controlled by legal process through a certain extent. But this political process itself cannot be treated in isolation. It is related to social process. It is related to economic process. And when we are discussing any issue related to electoral reforms, interdisciplinary and multidisciplinary approach is needed. I am happy in seeing that this seminar is inaugurated by a professor of political science who is now serving as the Vice Chancellor of Raichur University. Actually, in a trend for the seminar has already been set by the keynote address by Professor Girish. So I will like to say something related to the role of the law in the matter of electoral reforms, because at the implementation level, there may be some statutory provisions, or there may be even some amendment to the constitution itself. When we are discussing the legal framework for controlling electoral process in India, as all of us are well aware, we have constitutional provisions, especially in that constitutional provision, a moral philosophy is enshrined, that is the concept of universal adult franchise. Then independent authority for superintendent's direction and control of election is established. Then there are some provisions related to qualifications and disqualifications of candidates. There are some provisions related to electoral system, like a composition of parliament, state legislature, then election, and the system of election to be adopted for House of People, Electoral Council of States, and state legislative assembly, delimitation of constituencies, etc., etc. And through an amendment, 10th schedule is also incorporated in the constitution dealing with anti-defection. Whether that attempt is a futile exercise or not, I think this is a futile exercise. And in order to prove that it is a futile exercise, contribution from Karnataka is also very significant. Suppose the persons who are defecting from a particular political party resigned his position, contested election, and he or she got elected by the electorate. Then what is the relevance of this 10th schedule? There comes the point raised by the political scientists that there are certain limitations for controlling political process through legal process. Then, in addition to provisions of the Constitution, we have Representation of People Act 1951 dealing with the conduct of election, and Representation of the People Act 1950 dealing with the registration of voters, etc., etc. And we have conduct of election rules 1961, electoral registration rules 1960. So we have elaborate legal provisions for ensuring free and fair elections. My overall assessment is that we have sufficient provisions for the purpose of ensuring free and fair elections. But in one area, I think minor changes are required. That is the area of formation and functioning of political parties. Earlier, there were no provisions dealing with political parties. But after the introduction of 10th schedule of the Constitution, political parties came into the picture. Then subsequently, there was amendment to Representation of People Act dealing with a provision for registration of political parties. Now, we have legal provision for registration of political parties, but in the matter of recognition of political parties and allotment of symbol, there is no legal provision, in the sense that there is no provision enacted by the legislature or any provision made through rules in exercise of power conferred by a provision of law. Even today, it is governed by election symbol reservation and allotment order of the Election Commission of India. Election symbol allotment and election symbol allotment and reservation order 1968. Last year, one interesting thing happened in Kerala. There was a split in the political party, and a magistrate court issued a stay against a leader of the political party to act as the chairman of a regional party. That decision was upheld by the district court. Subsequently, a contrary view was taken by the Election Commission. Then a petition was filed before the High Court. Then High Court stated that yes, Election Commission's decision is correct. Then what is the significance of or relevance of the order issued by the Court of Law? Here, what happened was that though there is provision for registration of political parties, there is no provision barring the jurisdiction of the court. This situation happened because only for the purpose of registration of political parties, we have legal provisions. Regarding the recognition and allotment of symbol, only rules are existing. So I think that there may be at least an enabling provision for allotment of symbol, allotment and reservation of election symbol, and jurisdiction of the courts, civil courts shall be barred. Let Election Commission take the decision. Then that decision can be challenged before the High Court under Article 226 or even under Article 227. I think that is the best course of action. Then there are so many pertinent issues raised by Professor Girish. First thing is regarding our system of election. In 1970s and 80s and even 90s, so many discussions happened in relation to introduction of proportional representation. At that time, that is especially in 1980s, in the later stage of 1980s and 1990s, after the emergence of this Bharatiya Janata Party, BJP always argued for proportional representation. But now BJP is in power. Now they are not at all saying anything about proportional representation. Actually, it is dangerous in the Indian context to introduce proportional representation in total, because India is a country having more than 3,000 subnational groups. Cultural diversity, that is a part and parcel of our Indian civilization. So, in order to ensure adequate representation of all sections of the society, this territorial constituency system should be followed. But the question is whether for all seats in the House of People and legislative assemblies. At one point of time, a commission headed by I am not exactly remembering the person. I think it's Dr. N.R. Madhavan. Whether Professor Madhavan was the member or chairman, I am not remembering. They sent a questionnaire containing certain proposals. One proposal is that 50% of the seats in the House of People may be filled on the basis of proportional representation. Now we have, I think, 535 or something like that constituency. That number of constituencies may be double. Number of constituencies may be double. Now we are in the proposal. We are in the process of constructing a very big parliament house. So thus new parliament house can accommodate 1,000 or 1,100 members. Let 1,100 may be the total membership of the Lok Sabha. Let 550 may be elected on the basis of election conducted in territorial constituencies. Remaining 550 may be elected to proportional representation. Then we can do it in the stratified manner. Maybe district may be taken as a unit or state may be taken as a unit, but maybe. So we can think about introducing proportional representation at least for 50 or minimum 25% of the seats in the Lok Sabha and as. I think we can think about that. Another suggestion on my part is that no person shall be permitted to represent may be permitted to get elected or contest election to get elected to be a member of a legislative body more than 2 consecutive times. For example, the state of Karnataka Legislative Assembly, one person can get elected in 1990. Suppose election is in 2010 he can contest. Again 2015 he can contest. But after that, there may be a gap. If he is a very prominent leader, he can conduct election to Lok Sabha. And same principle may be made applicable in the case of election to Lok Sabha also. Because now certain persons are making manipulations to retain the constituencies. He may develop certain groups. Professor M.N. Srinivasan, sociologist, used a very useful term, very beautiful term to describe this undesirable practice, that is vote bank. In order to prevent the adverse effect caused by this vote bank system, if some limitations are imposed for permitting a person to make a constituency a monopoly, that may be useful. That is my point of view. Another point is that age limit may be prescribed for a person to represent their constituency. Maybe 80, no problem. Maybe 80. Maybe 80. 75, 80 or what may be. Some age limit may be prescribed. Then I will take only 5 minutes to mention about our serious vices in our election system. One is criminalization. Now we have provisions enacted consequent on this Association of Democratic Rights case that criminal antecedents may be disclosed. But I think there may be some categorization regarding the criminal case. Cases involving moral turpitude and other cases. Now the issue is that the newspaper may publish the report that out of the 100 candidates presented by political parties, there are cases against 80%. Most of the cases may be related to picketing or something like that. So there may be some distinction between cases involving moral turpitude and other cases. So such a categorization may be made in the affidavit. Secondly, in order to avoid criminalization in politics, what is needed is to make people aware of the significance of election. That point has already been raised by Professor Girish. To what extent our general public is aware of the factors to be taken into account for casting their vote. I think only 2 factors. Policies, programs and priorities of political parties reflected through election manifesto and through their past performance. Second one, individual merit and demerits of the candidate. Individual demerits and demerits of candidates. But now in election, so many other issues have been agitated. So in order to avoid this criminalization also, people should be made aware of the factors to be taken into account. Then coming to the individual merit and demerit of the candidate, definitely the issues like persons having criminal background will come into the picture. Then coming to the issue of money power, existing regulations are not at all sufficient. We may develop some system where political parties may be permitted to collect money and spend it in a transparent manner. Existing system is not at all sufficient, including this electoral bond system. Next thing is this media power. Actually, now this is the period of social media. There may be now there are provisions like rules like prohibiting this result of exit poll, etc. There may be some ban regarding opinion poll also, especially during the period from the notification of election. Let them conduct opinion poll prior to that. I think not only opinion poll, not only exit poll, opinion poll should also be prohibited. Then there may be some control to the social media. How it is possible, I don't know. But we may think about controlling, imposing some control on social media to spread fake news and other things during election. Actually, this fake news itself is a serious issue to be addressed, well, irrespective of the fact whether elections are going on or not. Then regarding the misuse of religion in election, there also what is needed is the creation of public opinion. Otherwise, it is not possible. We should now, Election Commission is conducting so many voters awareness program, etc. They are focusing on the issue that voting right is very important. How voting rights be exercised? What are the factors to be taken into account for casting vote? That aspect should also be taken into account. In that process, I think university can play a very creative role. With these stray thoughts, I am concluding my speech. I once again congratulate Karnataka State University, Law University, Professor Ishwar Bhatt and Professor C.S. Patil for organizing the seminar. Thank you very much.
Thank you, sir, for your thought-provoking address. Now, I request Professor P. Ishwar Bhatt, Vice Chancellor, Karnataka State Law University, Hubballi, to deliver the presidential address.
Professor Harisha Ramaswamy, Honorable Vice Chancellor of Raichur University, Professor Dr. K.C. Sunny, Vice Chancellor of NUALS, National University of Advanced Legal Studies, Professor Chidananda Reddy, Professor Jeevan Kumar, Professor Sudesh, Professor Vivijay Kumar, and all the resource persons, dignitaries, invitees. Let me first of all express my gratitude to our honorable speaker, Kageri ji, who had Vishweshwara Kageri, who not only circulated amongst various universities about the need to discuss the aspects of electoral reforms, but also made a phone call personally requesting for organizing a series of activities in the university and also involving various affiliated law colleges. I entrusted the work to the Center for Studies in Constitution and Parliamentary Affairs, Constitution and Democracy, headed by Professor Chidananda Reddy Patil. Of course, once I entrusted that work to a person like Professor C.S. Patil, then everything goes in a very systematic and smooth manner. I am very happy that he has planned it very efficiently, approached very right persons, and organized in a most effective manner. What is the contribution of universities or education institutions in bringing any kind of electoral reforms? Students are voters, especially, yes, most of the students are voters in our colleges. Of course, first year law students might not be voters, but in 1 year they become eligible for voting. Then inculcating in their mind insisting that they shall vote, and they shall vote in a free and fearless manner, and they should participate effectively in the electoral process. About all those things, if message is imparted, then of course university is contributing to the cause of electoral reform in its own way. Here we are going a step ahead, how electoral reforms are needed and how they can be brought, and what are the areas in which electoral reforms are required. Of course, preparing our students, or through students, even bringing awareness about the voting process or about the electoral system in the general public. That's one method of persuading the people that the electoral system shall be taken quite seriously, and various distracting factors like money power, muscle power, or caste power, power of religion, or communal power, and such things, they shall be kept at a check. and election shall be fair, free, pure, and reasonable. That particular message should be made popular, and through that, it is possible to ensure that at the stage of conducting of election itself, adequate safeguard is made. But it is essential that we should bring effective reforms, because through electoral system, we are connecting the people to the power process, and choice of leadership, choice of policies, and choice of some of the broader arrangements for development. All these things would be possible only through people's choice. That is why election plays a very crucial role. Just examine how after general election, the legislatures are busy with enacting a number of laws. Of course, when we compare the contribution of legislatures to the legal system in the form of making of laws, with the thousands of judgments that the Supreme Court and High Courts give, in a quantity or in a word length, the legislation may be less, but importance wise or significance wise, the legislative contribution is enormous, and it is immense, and it is a revolution. So many constitutional amendments, and bringing so many legislations, and amending those legislations, then supervising a whole body of the subordinate legislation. All these things are done by the legislature. Thus, the legislature plays a very important role. But how much time is provided to the lawmaking process? See, there we come across a serious doubt, because many times at the fag end of the session, so many of the bills are simply approved, and of course, elaborate discussion about the propriety of the policy is not adopted, or that is not conducted. That's not a very fair thing. About the loss of parliamentary times or legislative time because of, say, various types of in-house protests, etc. That's also something obstructing the democratic process. But coming to electoral reforms, today in the inaugural lecture, Professor Harish Ramaswamy has pointed out so the prominent things to be done by the concerted efforts of all the bodies like a legislature, executive, and judiciary. The contribution of a judiciary is also quite significant, because about the need for transparency and disclosure of the candidates' profile, or about the nota, or about the electoral expenses, or about the interpretation of the term corruption, or about the money power that shall be controlled. About all these things, judiciary has come out with very innovative views, very prominent judgments, which have changed the scenario, altogether. Because now, before election, the profile of each candidate is a matter of a public domain. all the voters know about the position of each and every candidate, his background, antecedents, his property, his educational qualification, and so many other things. Thus, they can make a rational choice on the basis of information. Then about the political parties also, through constitutional amendment, they're made players of the constitutional game. After 52nd amendment only that they entered into the domain of the constitutional world, and political parties are now entities which are subject to the constitutional obligations. Thus, they cannot make a discrimination, and they have to do so many things which are enshrined or prescribed under Part 3 of the Constitution. Then each and every member is bound by fundamental duties. Then about the oath of office and other things, the developments are such that they have to take all these matters of constitutional obligations quite seriously. The contribution made by legislation in the form of electoral reforms is a piecemeal reforms, and Professor Ramaswamy pointed out that during the last few decades, no substantive reform has taken place because no unanimity could be brought in this field, whether women shall be given a reservation, whether there shall be proportionate representation in addition to the first past the post system, in order that proper balancing between the percentage of votes gained by the political party and the number of seats obtained by them could be properly balanced. About all those things, much thinking has been made. Sri L.K. Advani had emphasized about introducing this additional system or a modified form of this proportionate representation system, list system, or such a thing. See, about electoral reforms, much has been contributed from the institutional side also. Election Commission has contributed. Not only the legislature and judiciary, even an Election Commission, by providing for an elaborate code of conduct, has emphasized on these matters. And Election Commission has undertaken some of the research projects, and one such research project is about feasibility of one nation, one election. Yes, when there are several federating units where state elections are conducted on a different date than the date on which national level Lok Sabha election is conducted, general election is conducted, then people are subjected to a lot of inconveniences because of the burden of having more than one election. See, some of the elections could be avoided, by elections could be avoided, or some of the elections which are necessitated because of the submission of resignation in order to switch over to a different political party, that also caused some burden upon the people. And it has been seen that the basic objective underlying anti-defection law has not been met, and judicial decisions about speaker's decisions or about the position of candidates who have changed the political sides. See, those decisions have not been that much effective in implementing the spirit of anti-defection law. Further, is it possible to control the political behavior through law? That basic question was raised by Professor K.C. Sunny in his keynote address. He made a very valid point, citing Professor Umapati, that the extent to which a legal process can control political process is something limited, and it has not that much potentiality, because a political process itself is influenced by social, economic, and cultural processes. Thus, a interdisciplinary approach is to be adopted in studying various electoral issues, and it is essential that the legal process should be effective, because ultimately it is the iron hand of law that will be able to control. Now, when a law has stated that there shall not be spending of money more than the required, the prescribed amount, then it amounts to corrupt activity if money power is abused and if there is excessive electoral expenses. See, how money power is to be controlled when elections demand huge expenses. Of course, political parties raise funds not through foreign contribution regulation, but through other means that they can do that, but they have to give accounts. If electoral bonds could be distributed, or if a state funding could be done, whether the position could be different. That's also one point that might be taken for discussion. But making electoral system free from money power is a very important task that shall be performed in a very meticulous manner. Honorable Justice Krishna Iyer, in a Vatal Nagaraj case and subsequent cases, repeatedly insisted on controlling the money power in a electoral system. Then about media power and the control of social media during the election, Professor Sunny has made certain observations. Of course, about the feasibility of it, we have to think. Regarding voting right, although we are to canvas about the duty to vote, citizens' responsibility to vote in a free and fearless manner. Still, how far people are convinced about that? That is a debatable issue. See, for a Lok Sabha election, the percentage of polling might be ranging from 60 to 70. For a state legislative assembly election, it may be ranging from 65 to 75. And for a district panchayat, it may be 75 to 80. And for a taluk panchayat and village panchayat, it may be going up to 90%. So people recognize the importance of their voting right, and closer the representative, more they will be willing to participate in an election. However, they are willing to participate. At least that is a good thing. See, when some of the countries like Canada or Australia felt that there is a serious downfall in a voting percentage, poll percentage, and somehow that is to be artificially enhanced, then they went on regulating the people's right. If they do not turn up for voting without justification, then they'll be subject to certain disabilities. Some of the civic advantages might not be given, or if there is a continuous abstention from voting for several elections, for a few elections, then they'll be permanently disqualified from voting itself. When a series of such regulations were brought, the percentage of polling shot up from 30% to 80%. See how through a stroke of legislative reform, it is possible to bring such a tremendous change is something revealing. It is essential to make use of such a stringent law and make it successful through education, because through legislation alone, it is not possible to bring reforms. Social reform can be brought through public education as well. Thus, electoral reform is a continuous process. We are looking for Professor Jeevan Kumar's interesting paper, how it is a kind of enduring phenomenon, and how repeatedly we have to involve in thinking about reforms and bringing reforms, because there is not a point at which we can be complacent that the position is perfect. No position could be regarded as a perfect. In a public domain, there might be certain defects. Electoral reforms, after so many such efforts from the side of various entities, has attained a lot of significance. So Sunny spoke about more than 10 lakhs constituencies. Of course, panchayat elections are taken seriously, and people even contest the electoral result. They go to court, and concerning each and every issue about panchayat elections, whether about fixation of a constituency, or about the roster system, or about counting of votes, and so many things. People go to court, and there is so much of awareness amongst the rural electorate that they shall participate, and participate effectively, and through that they should be able to shape the policies and programs of the system. Of course, in some parts of the country, like Kerala or certain parts of other states, we find that panchayat activities are quite vibrant, and they're doing quite well in response to the elections. Yes, the overall discussion by the scholars, Professor Harish Ramaswamy and Professor K.C. Sunny, have been about the comprehensive approach or holistic approach that is to be adopted. See, electoral reform cannot be piecemeal, and it cannot be done by one particular segment alone. People's participation becomes very much essential. Perhaps in technical sessions, as well as various paper presentations, those aspects will be brought to the limelight, and that will actually fulfill the objectives with which we organize this particular national webinar. With this, let me again wish all the best to the webinar. Thank you very much.
Thank you, sir. To conclude the inaugural session, I call upon Ms. Akhila Prabhu, Research Assistant at Research Center in Democracy and Constitutional Government, Karnataka State Law University, Hubballi, to deliver the vote of thanks. Please, ma'am.
Good morning, everyone. It is my privilege to propose a vote of thanks on this special occasion. Professor Harish Ramaswamy, Vice Chancellor, Raichur University, Raichur, was kind enough to inaugurate the national webinar on electoral reforms. Sir, we in Karnataka State Law University are grateful to you for the kind gesture. On behalf of the statutory authorities of University and Research Center, I express our sincere thankfulness to you, sir. Thank you, sir. With all respect at my command, I would like to thank Professor K.C. Sunny, Vice Chancellor, National University of Advanced Legal Studies, Kochi, for enlightening us with the keynote address. We wholeheartedly thank you for your cooperation and kind gesture. I would like to thank Professor P. Ishwar Bhatt, our Vice Chancellor, Karnataka State Law University, Hubballi, for presiding over the function. Thank you, sir. I thank Sri Mohammad Zubair, Registrar, Karnataka State Law University, for your kind support, sir. Thank you, sir. I thank Professor Ratna Baramgowda, Dean, Karnataka State Law University, and Professor G.B. Patil, Registrar Evaluation, Karnataka State Law University, for their valuable guidance and presence. I would like to thank Professor C.S. Patil, Center Head, esteemed faculty members of KSLU's Law School and other colleges, invitees, resource persons, paper presenters, and those who are present on the platform. Thank you, Manvinda.
Thank you, ma'am. With this, the inaugural session comes to an end. I invite Ms. Shraddha, student KSLU's Law School, to take over for the technical session.
A very good afternoon to one and all. A very good morning to one and all. My name is Shraddha, and I would like to welcome you all to the technical sessions of National Webinar on Electoral Reforms. I find immense pleasure in introducing our first resource person, that is Professor Dr. B Vijay Kumar. Professor Dr. B Vijay Kumar has obtained BA, MA, MPhil, ML, and PhD, all from University of Madras. Sir was the registrar of NSLIU and has administered the UNHCR chair on refugee law. He was a visiting scholar with York University, Toronto, Canada, and its Center for Refugee Studies. Apart from being a member and vice chairperson of the Board of Governors of the Asian Law Institute located in Singapore National University, Sir has held several teaching and prestigious administrative positions in various established universities. Sir has been awarded the Amity Academic Excellence Award and the Best Vice Chancellor's Award by Indian Red Cross Society. Sir has published more than 47 articles in national and international journals and has contributed to a couple of books as well. His areas of specialization include constitutional law, administrative law, human rights law, law of elections, refugee and humanitarian law. Presently, Sir is the Vice Chancellor of the National Law Institute, University, Bhopal. Thank you for being here with us, Sir. I now request Professor Dr. Vijay Kumar to share his thoughts on electoral reforms, a continuous process and analysis. Sir.
Right. Thank you, Shraddha. Dr. Chidanand Patil, Dr. Ishwar Bhatt, Vice Chancellor, Dr. Jeevan Kumar, my friend, and Sudesh. I could see some of the names in the first screen. If I have omitted anybody's name, my apologies. Good morning to everyone present here. At the outset, I would like to, Suresh Nadagowda is also here. At the outset, I would like to thank the KSLU for giving me this opportunity, for sharing some of my thoughts, sometimes maybe revolutionary, to the audience on a topic which is as important as any other right of the citizens in this country. If we are all, and more particularly for the law students, if we are all interested in good governance, I think we need to take these reforms much more seriously than simply paying the lip service. That is the first observation I would like to make. And that is the reason why I have also put the title in a very vague manner, that it is an ongoing, right, electoral reforms, a continuous process and analysis. So we have not reached what you call it as the excellent way of conducting the elections, and therefore the reforms will continue to proceed. Even if we have achieved that level, the process of taking or registering the votes from the electronic, I don't know, year afterwards, maybe your fingerprints will be the license to vote, right? There can be anything else. So that process will continue till we reach and stabilize ourselves. I think we are far, far away from that goal, right? That's my first observation. Let me just start with what Myron Weiner had pointed out generally about democracy in the countries, particularly the post-colonial countries. Myron Weiner pointed out that India is one of a handful post-colonial countries that could be regarded as having a stable democratic regime, right? Possibly he wrote when the first Congress government was there for almost up to 1967, right? From 67 to 87 for almost 2 decades, that stability was also not there, right? But this is what he wrote. The list is very small, and one could quarrel with the inclusion of several of the countries in it: Malaysia, Sri Lanka, Jamaica, Trinidad, Tobago, Papua New Guinea, and a variety of mini states like Bahama Islands, Barbados, Botswana, Gambia, Mauritius, and Suriname. In the main, post-colonial regimes have been one-party states, military bureaucracies, and dictatorships, communist or personalized autocracies. The new regimes typically restrict opposition parties, limit freedom of assembly and freedom of the press, do not permit competitive elections, restrain the judiciary from performing an independent role, and limit freedoms of the citizens in a variety of ways to speak out, to travel abroad, to criticize the regime, and to change the government peacefully. In most, this is most important, in most post-colonial regimes, political participation is restricted and leaders are not held accountable. And in the worst cases, governments are tyrannical. And finally, the last sentence he writes, it says, India, along with a handful of smaller countries, is a notable exception to this situation. So we did not go the Burma way. We did not go what Botswana enjoyed. We did not go the way that other countries in Africa or Asia or even South Asia did achieve or did not realize the sanctity of electoral process and sanctity of the democratic values. And therefore, they continue to struggle. And India, according to him, is an exception as one among the few countries, right? Now, I would like to just begin with a few other observations in which I would like to refer to the Election and Other Related Laws Amendment Bill of 2003, which is called as Funding Reform Bill, was approved by both houses of Parliament in August 2003 and became a law in September with the assent of the President. This 2003 law has brought in some important changes to the electoral process. Very quickly, to sum up, it gave full tax exemption to individuals and corporates on all contributions to political parties. And one can even contribute to more than one political party, right? It effectively repealed Explanation 1 under Section 77 of the Representation of the People Act by saying that the expenditure by third parties and political parties will now come under ceiling limits. Only travel expenditure of leaders of parties is exempt. So they are now bringing in all other expenses under the expenses incurred by the candidate, contesting candidate. Third one, disclosure of party finances and contribution over 20,000. Because the Companies Act was amended to provide what you call it as any person can contribute more than 20,000 rupees, but it must be only in the form of a check or draft. Cash cannot be accepted. I hope all of us know we have excellent human beings. So what I'll do is I will not give a check. I will give 19,999 rupees. Right? You have to accept it because law is law. If it is 20,000, then only you can demand a draft or a check. I'm giving 1 rupee less than that, so please accept the cash. So the cash flow in whatever manner, in spite of this limitation brought in, the cash flow into the coffers of political parties has not stopped yet. The indirect public funding to candidates of recognized political parties, like free supply of electoral rolls, right? And some other items by the election commissions, as are decided in consultation with the union government from time to time. Then equitable sharing of time by the recognized political parties on the cable television network and other electronic media, public or private. These are some of the reforms kicked in by the 2003 Amendment Act. But I think we have passed almost 20 years now. To what extent these things have been brought in, effective, to what extent we need to do something more, these are the things that we need to look at it as we proceed. The last point that I read out, that the political parties in the 2003 Act, equitable sharing of time by the recognized political parties on the cable television network and other electronic media. I think all of you know, let us not take this recommendation, this law seriously, because today every political party, regional or national, they have their own TV channels, right? If I have to speak about Tamil Nadu or Karnataka or any other state, Andhra Pradesh, Delhi, wherever you go, I think the ruling political parties, the opposition political parties, some significant political parties have their own TV channels, they have their own media houses, and therefore it is very, very difficult for us to regulate this particular aspect unless and otherwise somewhere the revolutionary changes that we are talking about comes in, kicks in, and limits the power or the authority of these agencies or bodies in the years to come. I think the news of this nature will continue to go on. The electoral reforms will not have the meaning or the desired result that it is expected to have. In the third place, I would like to bring to your notice an important amendment made to the Constitution, the 91st Constitutional Amendment made in the year 2003. Now, whether it has contributed anything immensely to the electoral reforms, I think as a student of both political science and law, I would rather see that it has brought in some semblance of reform, and very effective reform to say so. but it got diluted over a period of time. Once again, thanks to our courts. I would like to just take a couple of minutes on this. What did the amendment do? The 91st Amendment, the Constitution, 91st Amendment Act 2003, imposed a restriction on the total number of ministers in the Council of Ministers, which shall not exceed more than 15% of the total number of members in the House of the People or the state legislative assemblies. Now, all of you know the 52nd Amendment Act, which is called as Anti-Defection Law. In my opinion, I just call it as it never prevented defection, it only facilitated defection. Right? It was an amendment very hurriedly made, and then giving all types of power to the parliament and the state legislature, particularly the speakers and presiding officers. And therefore, the implications were before us. So we don't have to elaborate much on that. But this imposition of 15% ceiling on the total number of members, right, either in the Lok Sabha or in the state legislative assemblies, that is the strength one has to take in 15% of that. It imposes indirectly the circus that the coalition political parties play. There used to be what you call it as jumbo cabinet, right? Out of, more than 100 members were there in the Council of Ministers at one point of time, right? Or more than 120 members were there at one point of time. State legislative assemblies, particularly like Goa, the total strength may be 30. I think 28 of them were ministers at some point of time. Only 2 were not accommodated in the Council of Ministers, not because of anything else, but because one has to play the role of a speaker and the other one has to play this role of a deputy speaker. Now, this is what you see, the violation of what is expected of this constituent, the 91st Constitution Amendment. And as it brought in very strict regimen, not more than 15% in the Council of Ministers, then the lawyers, you and I are lawyers, the advisors to these governments have recommended that they can appoint parliamentary secretaries, any number. And you can designate parliamentary secretary X, who will have the cabinet rank, parliamentary secretary Y, who will have the rank of a deputy minister, and the member Z or Z, who will have the parliamentary secretary, but having the rank of a minister of state. Now, this brought in what you call it as strict violation of what the amendment is sought to realize or achieve. And therefore, to keep the political parties happy in a coalition, the political parties are willing to violate this 15% ceiling by calling them as parliamentary secretaries, a position which was abolished way back in 1967 or 68, I don't remember the year, that was abolished by the law made by the parliament. But I think the states started using them or misusing them in bringing them as the parliamentary secretaries. And what is even more worse is that there is a conflicting decision given by the high courts of West Bengal, Karnataka, and Delhi, right? This is a place where in one high court says parliamentary secretaries also are ministers in that rank, and therefore the appointment of parliamentary secretaries beyond 15% of the total number of ministers is unconstitutional. While the Delhi High Court said there is nothing wrong in it, right? So did the Karnataka government, the Karnataka High Court. So there is some sort of, what do you call it as, way in analyzing the 15% ceiling. One among the electoral reforms we are meaningfully thinking about it should focus on this and how to strictly, limit the total number of members in the Council of Ministers not to exceed 15% at any cost, right? This is one point which we need to keep in mind as we proceed. There is a good intention, but while implementing, I think we are violating the very constitution amendment which brought in this wonderful change. In the fourth place, I would like to make a mention about where the reform is required. Not that people have not spoken about this. They continue to speak about this. And that is why I said it is a continuous process, right? If it is a continuous process, then we need to include this also. The criminal records of elected and contesting candidates, right? Which is bothering all of us. In one sense, if all these people become elected representatives and they also become ministers of home, of important portfolios, then possibly you can see the impact that it can have on the democratic governance, transparency, and accountability. Now, one of the reports of the Association of Democratic Reforms very clearly indicate that the 17th Lok Sabha elections, 29% of the elected members, please carefully listen to this, 29% of elected members of the 17th Lok Sabha have criminal cases of rape, not criminal cases of smaller crimes, criminal cases of rape, murder, attempt to murder, and crimes against women. 29% of the elected representatives. And if they have to become ministers, then even God cannot save this country, right? If the statistics given by the Association of Democratic Reforms is correct, right? Please try to understand, they were only identifying 29% of elected members. But if you take the contesting members, the percentage will be much more higher than 29%. Which means every political party has the criminals representing them in the Lok Sabha today. This Association of Democratic Reforms gives the statistics as well. The JDU has 13 MPs with criminal record, not criminal record of small crimes. These are all the crimes like rape, murder, attempt to murder, and crimes against women and children, right? 13 JDU members have such criminal records. DMK has 10 members. The Trinamool Congress has 9 members of parliament. And BJP has 116 MPs. 116 MPs who have criminal records, right? Now, since 2009, 109% has increased in the number of MPs with serious criminal cases. In 2009 Lok Sabha elections, 162 winners had declared criminal cases against themselves as against 185 in 2014 Lok Sabha elections. So it's all in, 3-digit figure. Nothing has come down below this. So 29% is a huge percent, right? So therefore we need to look at it, but it is a very, very tricky issue because it's very difficult for us. The reforms suggested very clearly indicate at some point of time, if there is a case filed against somebody, that person must be prevented from contesting the election. But if you do that, just before the election being notified, I will file against a complaint against Chidand Reddy and Chidand Reddy will file against me, right? So both of us cannot contest the election. And they will not allow anyone to contest because the moment somebody contests, it is an allegation, right? So therefore, whether that is feasible, then the court intervened and said, no, you cannot do that. Unless and otherwise there is a prima facie case, right? At least in the trial court. At least in the trial court, then possibly one can do if the charge is framed. Then again they went to the court, no, charge is not there, at least the lower court must convict them. They cannot go on an appeal. If they go on an appeal, that cannot be considered, but there must be a conviction. And then they got convicted in the lower court. Then they go on an appeal to the High Court, and they want a stay so that till the High Court disposes of the petition. So which means till the High Court decides, he will continue to be a member. And then if High Court decides, again I have my right to go to the Supreme Court. Until the Supreme Court decides, I will not be disqualified. Now in doing so, from one court to another, I complete my full term of 5 years. Right? So the very essence or purpose of law in preventing people having criminal records, contesting the election, or getting elected as representatives still remains a very, very distant dream in the democratic process in India. So therefore, if you're all doing some research on the electoral reforms, please do consider, I think instead of looking at some act or something like that, this is an area on which I think lots of research can be undertaken, and then a lot of suggestion can also be done as to how to prevent the criminal record holders from contesting the election from time to time, not only from one party to another, from almost all political parties, and even as individual contestants. And therefore, we need to look at the criminal records of these individuals and how to prevent these people from contesting the elections will be a huge challenge for us, because as I very quickly mentioned, because I can go on for hours together on this. What happened in the trial court, what happened after the conviction, where they went and what the High Court said, right? And from High Court where they went, right? So I will come to, there is one more provision which I would like to refer to. I will also come to that, possibly I'll make a reference to this. Our judicial system is one among the delayed judicial process, right? In an attempt to give lots of importance to procedure, we are losing the substance in some form or the other. So the delay has taken away the steam out of these reforms, either criminal law or electoral law reforms. So this is a crucial point that you have to keep in mind as you proceed, right? The next issue that I would like to very briefly mention, I'm just mentioning these things briefly, keeping in mind that you have paper presenters, right? After 2 other presentations by me, and there is one more presentation to be followed. And after that, the paper presentations will continue. And I hope all of you will discuss these things in detail and find out what best we could do to prevent these things and make these electoral reforms live and kicking in the years to come. Then comes the misuse of electoral machinery during elections and just prior to the elections. I think the Supreme Court has also in a number of cases said, we follow the British parliamentary system, and therefore the elected representatives will continue to remain till the next house steps in. But there is a convention in England where, though the house is elected for a period of 5 years, after the 9th session is over, the 10th session will take place, that is the concluding session will take place within 6 months. And the Prime Minister recommends to the Crown, asking the Crown to dissolve the House so that the next fresh House can be elected and come into being within the next 6 months. So the last session, by and large, the House does not exist, right? This is a point which we need to keep in mind. But here it is not so. They continue to remain as elected members. They continue to remain as the members of the Council of Ministers, right? And then if they continue to remain as Council of Ministers, they use the government vehicle for the transport, communication, their ability and power to transfer, the civil servants from one place to another, announce schemes prior to the election, right? Before notification, you can see a series of schemes are being announced. It is because the government is in force. I just want you to apply your mind a little countries like Bangladesh, I want the law students and my colleagues in law teaching and research to take this little seriously. In Bangladesh, and if I remember right, the new constitution of Nepal, if there is a dissolution of the house, the chief justice will become the caretaker, government till the elections are held, and nobody represents the government as elected representative, which means there is absolute equality, between the contesting candidates in such elections. Whereas in India, the prime minister who continues even as a caretaker prime minister or as caretaker chief minister will continue to be called so, and hog what you call it as the prime time television channel, that so and so went there, so and so went here, cut this ribbon, opened this something or that. So they get what you call it as free canvassing. And then the candidate contesting against such people, the Council of Ministers or the elected representatives, will have the disadvantage at the starting point itself. That person will be contesting as an ordinary citizen, whereas all others will be contesting the elections as a sitting member of the parliament, sitting member of the Council of Ministers, and thereby offending the concept of equality under the Constitution. And we have not given our thought to this seriously. And I hope that we have to do a little bit more research and make the Election Commission and the Government of India and the states to realize these objectives, and then pave way for the electoral reforms, wherein the contesting candidates will have equality of status and opportunity in each and every election. And that should be our objective, larger objective, when we speak about electoral reforms. Then the next point that I would like to discuss with you is paid news, right? Paid news is, once again, it's a serious issue for electoral reforms, right? How is it a serious issue? I'll just give you some information so that you can appreciate what it means, right? According to the Press Council's report, paid news is any news or analysis appearing in any media, print or electronic, for a cash or kind as consideration. For cash or kind as consideration. The Election Commission of India found 120 cases of paid news during the 17th Lok Sabha elections in 2019. So it is going to be another menace in the elections, but there is no law to regulate the menace of paid news in India. Paid news is an obstacle in free and fair elections since voters are influenced by news reports. Paid news publishes as advertisement, totally misleading the electors. The paid news involves use of black money and underreporting election expenses. I think Chidananda Reddy and and his team must find out if it is an advertisement, misleading advertisement, whether they can be brought under Consumer Protection Act also, right? To say that you are giving a misleading advertisement and therefore you have misled the voters. So you have to pay huge compensation too. Let us try that in a public interest litigation, right? If a judge agrees, then I think this is the best way to stop this paid news, right? Otherwise it is increasing, and this will increase, as I mentioned to you. Every political party has its own platform, electronic media, print media. I'll just take the example of Tamil Nadu, where the two leading parties, DMK and ADMK, they have their own channels. And you would have seen in the two recent floods in Madras city, one TV channel was only showing the chief minister, right, going and distributing all sorts of things to the people, discussing with the people, discussing with the fire safety officials, so on and so forth. Not even a little about what the other political parties have done. While the other political party sitting in opposition, this may change from one election to another, will show only that their leader has been doing lot many things and the chief minister is not to be seen anywhere in that place. So this is nothing but false propaganda of each other, against each other. And if this is possible even during a natural disaster, I think its velocity will be much higher in the electoral process. And therefore, we need to look at this very carefully. And this also gives us lots of opportunity to think about the PhD research or LLM dissertations on such areas which can kickstart something different, which is not based on the existing literature, something which you can, the youngsters can bring their ideas into fruition by suggesting whatever means through which they can prevent the paid news from happening or hampering the process of the electoral process in India, particularly, right? The next one, less spoken about this is better. It's a continuing process. It is called as Office of Profit, right? Now, the Parliament has enacted a law, and so did almost all the state legislatures. The intention is to protect somebody who is elected if somebody was holding an office of profit, so that the person is not disqualified. So they started giving exemptions, right? And today, if you see these laws, they all exempt almost every offices. Very little is given. Ultimately, the matter went to the Supreme Court. The Supreme Court was brilliant in this case. It said, even retrospectively, you can make an amendment so that the person will not be disqualified. Now, please carefully look at this judgment, where the Supreme Court says, right, it was a case against the sitting president of India, right? And the court said, even retrospectively, if they have amended that parliamentary law, then it is valid. Where is the sanctity of law? Where is the sanctity of the office of profit, right? And this is one gray, it is not a gray area, it is only gray law, which we need to look at it. If at all something needs to be done, otherwise you allow everyone to contest. Recently, I was also involved in some consultation by the UGC, the teachers contesting the election, right? Whether they are holding office of profit. Today, I think there are lot many private and public schools available, right? If you are appointed by the government, the salary is paid by the government directly or indirectly, you are disqualified. But if you are working in a private university, right, you are not disqualified because you are not appointed by the government. Is it that, it is appointment? Is it not the position somebody is holding? Is it of public importance, right? And whether his work will be affected either here as a teacher or in the parliament as a representative, elected representatives. Why they can't think? This is what I suggested. If they are elected, let the educational institution give them 5-year unpaid leave, right? Let them focus, concentrate exclusively on democratic process for 5 years. And so that the service is not discontinued, private or public, they will continue to remain on roll, but they will come back after the term is over, after the house is dissolved, so that they can continue to do their work as teachers. But I think a majority view was against what I said. They said, no, they should be getting a salary from both the places. Whenever he finds time, he'll come and teach. And whenever he finds time, he'll go and sit in the house, right? If this is the case, a person cannot ride 2 horses simultaneously, right? And if one horse becomes weaker, I think he will neither do justice to his teaching nor justice to the people who elected him as the representative. So this office of representatives has a huge potential for us to do research and then find out. Now Bar Council is also caught up with this question because many members who are elected, they are all leading lawyers of the country, right? Now, can they practice in the Supreme Court, right? There are many doctors. Can they practice in the, hospitals and then whenever the house convenes, they will attend that house? No, I think somewhere something is going wrong. We need to understand these things. Either you represent and give 100% dedication to the people who elect you, or give 100% dedication to the profession to which you are qualified. Therefore, office of profit is a huge issue that will continue to hog this electoral process in the years to come, because they have exempted almost everything. And they are in the process of exempting few more. And these laws will become obsolete in the years to come. And therefore, the electoral process need to address this particular issue much more carefully. I will not, because electoral and the office of profit, with the case law and others, I can go on for at least 4 to 5 hours minimum, right? That is not the intention, but I am just giving some flagging some important issues as the electoral reforms as a continuous process, right? Then comes something very interesting. I want you to please carefully listen to this. Section 8, 9, 10A of the Representation of the People Act 1951 speaks about subsisting disqualification. The language used is will be continued to be disqualified, but I'm using the phrase subsisting disqualification, which indicates the same thing. What is this subsisting disqualification? Under these 3 sections of the ROP Act, Representation of the People Act 1951, if anybody has committed the crime as mentioned in these 3 sections, they will be disqualified from holding the office as a member of the State Legislative Assembly or the member of Parliament, either house of Parliament, right? From the date of such a declaration that they have committed such a crime and they are disqualified, for next 6 years, they cannot contest the election. This is called as subsisting disqualification, right? See the beauty of it. On the date of disqualification, on the conviction of a crime committed by the elected representative, under these 3 sections, there are other sections as well, sections 8, 9, and 10A. From that date onwards, the subsistence from 3 years to 5 years, 6 years, it may change, but it gives 6 years maximum of subsisting disqualification. What possibly you will remember is Shashikala's disqualification, right? The ADMK Supremo, who was convicted by the court in Karnataka, right? And she has been sentenced to 4 years imprisonment. And then after she completes that 4 years term, 6 years she cannot contest the election. She can be a leader of a political party, but she cannot become elected member of the house. And this subsisting disqualification is very, very crucial. This is intention of the law is excellent. Let us now come to the practical aspect of how it happens. Now, once a person is disqualified based on any of these sections, he immediately appeals to the High Court, right? He runs to the High Court. The High Court immediately provides a stay. To vacate the stay is not that easy, right? And then by the time he completes his or her term, the effectiveness of these sections are totally diluted because of this process. Okay, at least he completes his term, that's okay, right? 5 year, it's a bad dream, we can forget about it. But there is subsisting disqualification, right? I have a case which I don't want to, disclose. It happened from Karnataka State Legislative Assembly. The member had a subsisting disqualification for 6 years. He contested the election. Before, when he filed the petition, when he filed the nomination, the contesting candidate said he has got subsisting disqualifications so that he cannot contest that election. The returning officer said that I will not take it into consideration. You have to challenge it only in the court of law. So he was allowed to contest the election. He contested the election, and in Indian democracy, it's very interesting to note such people get elected. and he got elected. Then the candidate who lost the election went to the court saying that he had a subsisting disqualification. He cannot continue as a member. It prolonged for a long time. Finally, when the High Court took up the case for decision, he had completed even the subsisting disqualification of 6 years. So in theory, the law seems to be very good. But in practice, I think we see that subsisting disqualification period also evaporates, and those individuals continue to hold the office, enjoy all the benefits, and we are not able to do anything. And is this an electoral reform point? I think if this is not electoral reform, what else can be the subject matter for electoral reform? Please carefully look at this section and find out how to prevent such subsisting disqualifications. Once a person is disqualified on these grounds, I think there must be some method through which he could be prevented from contesting the election. So they must authorize the returning officer not to accept the nominations. But we don't have any such procedure now. It is all left to the court. And when it goes to the court, the delay that it causes allows all these well-intended legislation or legislative provisions are not able to be implemented effectively. Right? So this is a point which we need to look into. In the context, I am also saying this, where the court's right in delaying it, I would like to bring to your notice Section 86, subsection 7. Please carefully read this section. Section 86, subsection 7 of the Representation of the People Act 1951. Right? Please carefully read the content of this section. I may not be reading it completely, but the crux of it, I will just read it out. Election petitions shall be tried as expeditiously as possible. See, this is what law mandates. As expeditiously as possible, and endeavor shall be made. And see, there is a rider on this, because what is as expeditiously as possible may vary from individual to individual, court to court. For me, it may be 2 months. For some of you, it may be 1 month. For somebody, why 15 days? Some of you can say, why not 1 year? And some of you can also say, why not 5 years? As expeditiously as possible. And therefore, a rider was also added in this section, as expeditiously as possible, and endeavor shall be made to conclude the trial within 6 months. Please carefully read this section. Within 6 months from the date on which the election petition is presented to the High Court for trial. So from the date of filing the case in the court, in the High Court, within 6 months, they are supposed to dispose of the matter. But I have given you a couple of examples where not only they completed the tenure, but they also continued and contested and completed the tenure, even with a subsisting disqualification. And I think there is every need to look at and analyze this particular subsisting disqualification, so that any reform that we are talking about in future will incorporate changes in this as well. Then comes a major issue, public funding of elections, right? There have been a number of reforms that have been suggested, right? Public funding seems as a solution, but it has more problems identified by people, right? I will just read out some questions which I framed for implementing the public funding, right? Because it's very easy for anyone to say public funding of election must be given, but how it is to be done, I would like to just mention some questions which I had framed in my paper. How can the state raise resources of huge proportions to fund elections, right? Today, every state is filled with coffers, right? Only Corona reduced that to a great extent. But I think every state is comfortable enough. So whether the state can raise resources, I think the answer is yes. But still the question continues to august as we proceed. Second question, what should be the name of the fund so raised? Who will keep it? Who would administer such funds? Is the third question. On what aspects of election such state funding will be permitted? Should they be regulated or should it be based on the claim of the contesting candidates? Who would maintain the expenditure of the contesting candidates? And finally, how to limit the state funding only to serious candidates and prevent a large number of independent candidates from entering the fray? So if you try to respond to this half a dozen questions that I have posed, I think the answer will emerge. A certainty will emerge, because with the Election Commission having a 3-member body, one can be a chartered accountant who can manage the funds, the state fund, in such a manner that no one else can do. And how will you raise the funds? I think the Companies Act has already given you the opportunity. I think any corporate officers, individuals can contribute. You can give some tax exemption, already tax exemption is given. So raising the fund is not a big issue, right? Who would administer is not an issue, right? What should be the name of the fund is not an issue. But on what issues, what aspects of election state funding to be permitted? I think that is a question which we need to take it up. For electioneering, 14 days, right? Maybe printing of banners, not writing on the walls. Printing of banners. I was in the US when Schwarzenberger was contesting as a candidate for the Senate. I also went with the campaign trail for 1 full day. That is what we are supposed to learn. So I went there. So on what can you spend? They have what you call it as, in each and every house, you can see a small placard saying, please vote for Schwarzenberger. It is in blue color or in red color. You can easily see Democratic and Republican. Nobody writes on the wall. Nobody prints big banners like what we see today from the airport to the secretariat, right, or to the Chief Minister's house or the Prime Minister's house. Nothing is seen. So we need to understand, instead of dirtying the wall and public places, 14 days, an equal opportunity is created. On what it can be spent, I think it should be done. Newspaper advertisement, even if they want, let the government give the money to that. Every contesting candidate can be given that opportunity. And canvassing, instead of electioneering, they can address the people from the local channels, which will be very effective, through radio, through FM radio, right, through social media. All of them can be regulated, and the cost incurred can be equally given to every contesting candidate, so that equality is maintained, right? Now, who will maintain? If all these things are identified, it is much more easier for that chartered accountant member of the Election Commission to maintain the election expenditure in a detailed manner, right? But the last question remains an issue: how to limit the state funding only on serious candidates and prevent a large number of independent candidates from entering the fray. Because if free funding is given, even I would like to contest. I may not know who my neighbor is, but still I would like to contest. There is always a solution if you think it seriously. And, in the election, the existing electoral laws, you have a provision that a candidate who is getting less than 1/6 of the total votes polled, right, will lose the deposit. You fix some other criteria less than that and say that unless and otherwise you secure this percentage of votes or these many votes as against the total, voters available, you have to repay the entire expenditure to the government exchequer. If you are not able to pay, it will be taken as a revenue, due, and the government can proceed against that individual. I think this will take care of the last question that I referred to, how the state funding can eliminate non-serious candidates. So therefore, there are opportunities available. We need to think a little more rationally and try to bring these reforms as we proceed. Very quickly on one aspect, there was a rule at 59A of the election rules, which said after the ballot papers are taken to the counting centers, what they do is the bundles of the booths, they get mixed up, right? They intentionally mix up the the bundles of each and every booth, and then take it as a constituency, so that nobody will get to know from which polling booth the votes have been cast. If the elected candidate or the last candidate sees that in spite of the good amount of money and effort that he has spent, that the people have not voted, he may try to take vengeance and go on a rampage, which has happened in a number of cases. Ever since the electronic voting machine has come into picture, we have not have this Rule 59A being pressed into service. So therefore, they have proposed something called as totalizer. What totalizer does is precisely what section of the Rule 59A does. Mixing up of the electronic votes of each and every polling booth per constituency, so that individual polling booth details are not disclosed, which is a very, very pressing need that we need to look at it, address it, and implement it at the earliest, right? Then restrictions on government-sponsored advertisements and schemes. 6 months before, already I made a mention, so I will not get into the details of that. But I can only tell you that it very clearly violates Article 75, Clause 3 and 164, Clause 2. When the houses are not in session, how the caretaker Prime Minister or Chief Minister will be accountable, and accountable to whom, is an issue. But I think if we understand this equally, properly, then the equality and rule of law can prevail among all the contesting candidates in the years to come. Last but 2-3 important issues which I would like to mention. Simultaneous election. Simultaneous election. There is so much of opposition, right? I don't know why there is so much of opposition in this, but if you just go through the statistics that are available in the public domain, you have what you call it as the elections that have taken place right from 1952, right from 1952 to 2019. The total number of booths have increased, total number of voters have increased, right? But the reliance on technology also has increased manifold. And therefore, it is easier for us to look at the technology as a tool through which we can go to the polling booth only once in 5 years, bring in that revolutionary change, if at all we need it, for the Lok Sabha, the state legislative assembly, the panchayat and municipal elected representatives in one go, right? Please look at what is happening in the US. Every 2 years, there is an election taking place. And whenever the presidential election falls in, the election takes place in the same booth for the president, the vice president, the senator, the representatives, right, in the lower house. And then you also, some of the states have judges who are being elected, and their names are also given. So 5 to 6 sets of people are elected in one single process. If that is possible there, with lots of electronically modified electoral process, why can't we think in terms of election only once, and the dissolution of electoral the assemblies by the center, according to the whims and fancies, will also come to an end. And therefore, democratic institutions will continue to flourish. And this is an issue which we need to look at it and carefully articulate on what you call it as simultaneous election to all the 3 elected bodies, the Lok Sabha, the legislative assemblies, and the local self-governments, right? And one important aspect which I need to mention, we are all going to be lawyers, the students and the teachers and researchers who are all already lawyers. We know what is meant by the affidavits, right? I think we can say anything through affidavit. Except the truth, we say everything. Now, unless and otherwise there is a law, I hope this Watergate scandal, right? Perjury, giving false evidence under oath. Even the president of US was prosecuted, was sought to be prosecuted, right? But here, even an ordinary citizen cannot be prosecuted and punished. The courts take them very lightly. The courts know that this is a false affidavit, but still they don't take any action, meaningful action. I think we need to do in the electoral process also, they give lot many affidavits and the veracity needs to be looked at it. And if somebody is filing false affidavit, then I think much more serious action must be taken against them. Just to conclude, I know that I have passed my time. There are a lot many regional consultations that have taken place that need to be integrated. And I thought I'll also discuss about the role of the judiciary in having what you call it as contributing to the electoral reforms. I will just very quickly take up one single judgment of the court, Subramaniam Swamy versus Election Commission of India, where they said, in a polling booth, if I give the paper ballot, there is a proof that I have cast my vote to somebody. But here, I don't see anything. I press the button. I don't know whether my vote has been registered against that particular individual or not. And this was very seriously taken note of by the Supreme Court. And constantly they interacted with the Election Commission. And the two manufacturers of the electronic voting machines were brought in for consultation and presentation in the court. And they also developed what is called as voter identified, that VVPAT, right? Voter verifiable paper trial audit, where paper audit trial came into existence with Bharat Electronics and Electronics Corporation of India Limited coming together and developing a prototype. And then this was tried in all environment, very hot, very cold, right? Every environment they have tried. It functioned very effectively and efficiently, but for the political parties challenging that the result is because of the electronic voting machine. Today, this for 7 seconds, the citizens can also see the vote. It is cast, the emblem will be there, and the name of the candidate also will appear. The button that you have pressed, automatically it also comes in. It gets into a box. You will not get a copy of that. But in the event of any question raised, these paper ballots will be taken and counted. And in all the trials that they have done, it 100% goes well with the electronic voting machine, right? And therefore, we need to look at the role played by the court in bringing out some electoral reforms. We need to use them effectively and think in terms of providing much more than what I had discussed. And I hope that the representatives and the Election Commission will take note of all your suggestions. And I wish that the deliberations that you have in the afternoon or paper presentations will be much more meaningful and useful to the society in which we are living. Thank you very much for your patient hearing.
Thank you, sir.
Thank you so much, sir.
Next up, we have with us Dr. B Jeevan Kumar. Sir has more than 38 years of teaching experience in political science and has attained superannuation as professor in July 2016. He has taught a wide range of papers which include development, politics and administration, Indian foreign policy, etc. He has occupied various positions of responsibility in reputable institutions. He has also served as special officer to the Vice Chancellor. He has visited countries such as USA, Germany, Belgium, Japan, etc. on academic assignment. Dr. Kumar has edited multiple books. The Angry Voter, Uniting in Responsibilities in a Culture of Rights are a few among them. He has also published innumerable articles in edited books, journals, and newspapers in his areas of specialization. Currently, apart from being a consultant to the Karnataka regional branch of the Indian Institute of Public Administration, Bangalore, he is also a visiting faculty at the National Law School of Indian University, Bangalore. On behalf of everyone present here, I extend a warm welcome to you, sir. I would now like to call upon Dr. Jeevan Kumar to speak on electoral reform for electoral equity, a case for consociational democracy. Sir.
Thank you. Thank you, Shraddha. I have a PPT. Is it possible to use that?
Yes, sir, you can use that, sir.
Yeah.
Yes, sir, you must be able to use it. 1 second.
Yeah, thank you. One minute, I'll just bring it to. Yeah, thank you. Good afternoon to all of you. It's been a pleasure to listen to some very good presentations on electoral reform, particularly the last one by my good friend, Dr. Vivijay Kumar, that has been extremely comprehensive and well thought out. Dr. Vivijay Kumar has also given a lot of suggestions for researchers to take seriously, because this is an issue, as he himself titled his paper, Dr. Vivijay Kumar, it's electoral reform is a continuous process. A lot of things are happening which we need to be aware of. We need to juxtapose what is happening in the interpretation of the law, what is happening through the judicial process, what is happening as far as people are concerned. A lot of issues are juxtaposed with electoral reform, and therefore I'm happy that a very comprehensive look at the entire issue was made by Dr. Vivijay Kumar. Let me thank Chidanand Patil Dr. Chidanand Patil for getting in touch with me and requesting me to be part of this exercise. And as the Honorable Vice Chancellor, Professor Ishwar Bhatt also mentioned, this is part of an important initiative, I think, undertaken by the Speaker of the Karnataka Legislative Assembly, because they had a lengthy debate on electoral reform. Leaders of all political parties spoke at the Karnataka in the Legislative Assembly. And one of the outcomes of this extended debate was the need to get a variety of opinions from various stakeholders, particularly from higher educational institutions, and a letter from the Speaker to leading universities in Karnataka, to higher educational institutions, followed by phone calls, as the Honorable Vice Chancellor was saying, a phone call from him also, has been instrumental in opening up an area for, I think, fresh inquiry. When Dr. Chidanand Patil asked me to choose an area that I would like to speak on, I chose this particular topic. It's not comprehensive, it is more or less specific, but I've titled this Electoral Reform for Electoral Equity. And my subtitle is A Case for Consociational Democracy. Now, we in political science keep looking at democracy from a variety of aspects. Professor Harish Ramaswamy made a reference to democracy, made a distinction between substantial democracy and procedural democracy. And one of the points that Professor Harish Ramaswamy made was the fact that there is need for democracies not to focus on being mere procedural democracies, but to undertake a serious transition from procedural democracies to substantive democracies. Taking the current issue as a case point, it's important not to merely be content with the fact that we are holding elections regularly. As the Constitution indicates, every 5 years elections are indeed being held. But would that qualify India to be called a substantive democracy? I don't think so. holding of elections does happen in many parts of the world, many democracies. But merely holding elections regularly, I don't think would qualify a democracy to be called a substantive democracy. We would qualify to be called a procedural democracy, but definitely not a substantive democracy. And from all the presentations that were made this morning, it is very clear that unless we take electoral reform seriously, I think our democracy may continue to flounder, not among the best of democracies, but somewhere perhaps in between. And therefore, what I've tried to do is to make out a case for electoral equity. When you take a look at the electoral system that we are following in this country and ask the question, does the electoral system reflect or is it indicative of electoral equity? And in political science, at least some of us are clear that whatever electoral reform is being contemplated, is being spoken about, at the end of the day, if that electoral reform does not translate into electoral equity, then there is a problem with what we are trying to do. And from this perspective, my hypothesis is very clear that when we are engaged with electoral reform, when we're looking at electoral reform, we need to look at electoral equity very carefully. And this is where I seem to think, and there are a few scholars whom I've quoted in this regard, who seem to think that the kind of democracy that electoral reform is talking about cannot be the democracies that we seem to be happy with, we seem to be content with. Currently, the electoral system that we are following is content with the kind of democracy which is called majoritarian democracy. Majoritarian democracy is convenient. Majoritarian democracy is effective, is efficient. There are many virtues of the kind of democracy that we are currently practicing in India and in many other parts of the world. But the reality is that this democracy is majoritarian democracy. And I'm using this term very carefully. Majoritarian democracy may be convenient, may be simple, may appear to be effective, but there's a problem with majoritarian democracy because the term majoritarian itself implies, I think, a certain problem. Do only majorities matter in a democracy? That's the issue that I've tried to pose, raise, and answer in my paper. Democracies are for everybody. Democracies are not only for the majority. And the moment one uses the term majority, the term minority immediately comes to mind. Majoritarianism, majority versus minority is a frequent equation that constantly keeps appearing in the public discourse. The majority says we are in a majority, therefore we have every right to call the shots. We have every right to dictate terms. We have every right to dominate the discourse, be it electoral, be it otherwise. That's what we are seeing happening in this country, particularly of late. That is the majoritarian argument. But in diverse plural societies like ours, is it not important for us also to look at the role of the presence of, the identification of, the satisfaction of minorities in a democracy? So if the electoral system believes in majoritarian democracy, the question before us is, well, what about the minorities? Do they not matter? Do they not count? And the minorities in a system, in an electoral system, are continuously put on the defensive. If the minorities are not contesting in adequate number, if the minorities are not given candidature, are not offered tickets in a sizable number, and if they are bypassed, if they are sidelined in the entire electoral process, can we label that system as a system that upholds electoral equity? So for all these questions, I have an answer maybe theoretical, but I'll also give you practical examples. I think in India particularly, if you are looking at electoral reform, there is a clear case for a transformation or for a reform of the democratic system itself. If we are believing and practicing majoritarian democracy, I think it's time we also turn our attention to look at an alternative, which is called consociational democracy. I'll go into the details as I proceed, but this is the title and subtitle of my presentation. And I hope within the time given to me, I would be able to do justice to the topic. By way of a preamble, I would like to elaborate upon some of the points that I briefly referred to earlier. And this is not necessarily with reference to our country. It is, I think, a broader perspective of democracies, of minorities, and of the multi-ethnic character of the population in diverse societies like ours. So I'm sure all of you would agree with me when I state that the multi-ethnic character of the population in any country must be reflected in its institutions, be they deliberative institutions, be they parliamentary, legislative institutions. And from these institutions flow policies, and from these policies flow practices. And therefore, what I'm saying, I think, is something that none of you would disagree with, that if the population is multi-ethnic, if the population is diverse, and if the population is as diverse as in a country like ours, it stands to reason that its institutions, its policies, and its practices are reflect this multi-ethnicity, reflect this diversity. The political participation and representation of minorities, according to me, are important aspects of minority rights. And it's not just me speaking about this point. You find it reflected very clearly, both in international law as well as in domestic law. Now, who can deny? Can the law deny that the minorities have a place in any country, particularly in democratic countries? Can the law deny minority rights to people belonging to these minorities? I'll also elaborate on this point a little more before I go into the legal aspects by saying that we need participation of minorities in public life. We need representation of minorities in public life. Why is this aspect, or why are these aspects being emphasized? Obviously, to ensure that the interests of these minorities, that the concerns of these minorities are taken into account. Because if they are not even represented in deliberative bodies, if they're not allowed to participate in the public discourse, well, who will take care of their interests? How will their concerns be addressed? I think if you're looking at development, be it social, political, or economic of a society, it stands to reason, and great minds have reflected upon this. I don't want to go into all their names. That if development is to be, if social, economic, and political development has to happen in a comprehensive fashion, in an inclusive fashion, I think it's important that we need to listen to the minorities and take into account their concerns. Coming back to the legal aspect, today, minority rights are considered as third generation human rights. All of you are students of law, and you're familiar with the distinction in the human rights discourse. The earliest of the rights were described as first generation human rights. Then we moved on to second generation human rights. Today, of course, we moved on to fourth generation rights too. But when the matter of what kind of rights do we include in third generation human rights, the minority rights became very prominent. And this is recorded in law, both national as well as international. Particularly in international human rights law, minority rights are very clearly described as third generation minority rights. And when we have the effective participation of minorities in various areas of public life, well, you can say that your country is truly democratic, that you're talking about development which is cohesive, which is inclusive, and that justice prevails in such a society. All of this I'm stating by way of a preamble, because I think I'm trying to set the ground for what I wish to elaborate in a little while. But before I do that, let's also take a look at some of the legal. Let's take a look at some of the legal provisions in international law. I'm quoting Article 25 of the International Covenant on Civil and Political Rights. The right of everyone to take part in the conduct of public affairs, directly or indirectly, as well as to vote, to be elected, genuine elected elections, and so on. All of this is part of international human rights law, specifically ICCPR. I'll also request you to take a look at the UDHR. Now, this is an outcome of Article 21 of the UDHR, which states that everyone has the right to take part in the government of his or her country, directly or indirectly. So international human rights law is very clear on this. I'd also draw your attention to one more document, which is popularly called the UNDM of 1992. Not many of us may have heard of this, but it's useful to take a look at a couple of articles in the UNDM of 1992. This stands for UN, United Nations Declaration on the Rights of Persons Belonging to National, Ethnic, Linguistic, and Religious Minorities. Take a look at Article 2.2 or Article 2.3. Persons belonging to minorities have the right to participate effectively in cultural, religious, social, economic, and public life. They also have the right to participate effectively in decisions at national level, regional level, concerning the minority to which they belong or the regions in which they live. So UNDM is also very clear as far as the rights of persons belonging to minorities, and the variety of minorities in our country who are entitled to participate in the electoral process, who are entitled to contest, entitled to win, to represent their constituencies, and so on and so forth. Having said that, by way of a preamble, but I've also drawn your attention to international law on this particular aspect, let me briefly turn to electoral systems and representation of minorities. There are a few points I would like to briefly share with you. Now, when electoral systems are being devised, I think it's a big challenge for the constitution makers to figure out what kind of electoral system is required for countries. How should those electoral systems be made equitable, at the same time be efficient? Now, these are huge challenges that every country has faced. Those of you who are familiar with the Constituent Assembly debates will also be familiar with Dr. B.R. Ambedkar's role here. And at the end of the day, when Dr. B.R. Ambedkar has said, now we are ready, this is the electoral system that we're going to practice. And when Dr. Ambedkar said that we are going to follow the FPTP system, the first past the post system, please go through the debates and you will find a lot of resistance to the FPTP system raised by several members of the Constituent Assembly of India. Quite a few members were very unhappy with the FPTP system. Please note what I said earlier. The FPTP system fits into a kind of democracy which we describe as majoritarian democracy. I'm sure you're students of law, you would know that the FPTP system is full of flaws. The FPTP system is convenient, it is easy, and at the point of time when we went in for our first election, 1952, it's obvious that with a literacy rate, with a very low literacy rate, it was not possible to go in for any sophisticated or advanced systems of elections. And therefore, at that point of time, it appeared, given our literacy rate, that there's no option but to go in for the first past the post system. Okay, there's no option for it. Dr. Ambedkar says this in so many words. But then if you look at the arguments raised by several of the members of the Constituent Assembly, who said that this is not going to be fair, especially as far as minorities are concerned. The FPTP system is not going to be fair to a lot of people. It may help you to complete the electoral process very quickly. It may help you to announce the elected candidates very quickly. It may help you to constitute representative assemblies in the Lok Sabha very quickly. But then there are a whole lot of laws, some of which were pointed out by representatives of the Constituent Assembly when Dr. Ambedkar said, we have decided to go in for the first past the post system. At that point of time, perhaps there was no alternative to FPTP. But today, in 2022, when we're debating electoral reforms, do we still continue to harp on, do we still continue to pin our faith on the FPTP system when the literacy rate has been completely transformed from what it was in 1952 to what it was in 2019? Given that factor and a whole lot of other developments, I think it is time that we seriously introspected on the continued relevance of the first past the post system, the FPTP system. I'm happy I noted that in the afternoon session, one of the papers is specifically looking at the FPTP system. So I don't want to go into a further analysis of the FPTP system, but I'm sure you're familiar with the fact that this system may be simple, may be facile, may be easy, but it raises a whole lot of questions about majoritarian democracy and about the representation of minorities. This is where I'm stating that the electoral system is at the cornerstone of democracy and has important consequences for the constitutional system, for the political system as a whole. So my major argument this afternoon, ladies and gentlemen, is this, that if we are looking at electoral reform, we can look at a whole lot of issues that have been raised by the earlier speakers, particularly by Professor Vivijay Kumar. We can look at all of them. But my question would be, where do we begin looking at electoral reform? And from a political science perspective, I'm very clear that any attempt at reforming the electoral system should begin by looking at the kind of democracy that we are practicing, the kind of democracy that an electoral system tries to enforce. And if that democracy is labeled as majoritarian democracy, I think this needs to be reformed. I think that we need to move from, as Dr. Harish Ramaswamy said, we need to move from a procedural democracy to substantive democracy. And if we are serious about this shift from a procedural to substantive democracy, then I think this majoritarian democracy mindset would have to be changed. The systems, particularly in this case, electoral systems that are juxtaposed with majoritarian democracies, I think we need to take a fresh look at that. That's the basic argument that I'm making here. While there are some basic elements of participatory democracy present in all methods of elections around the world, when you look at the details of electoral systems, by and large, there are these two systems. Two main families dominate. There is the plurality majority system. I've been using the term majoritarian democracy. A more technical term would be to describe majoritarian democracies as following the plurality majority system of elections. That's the one which we are following. Many countries continue to follow that, but there is an alternative. There's a brief reference to the PR system. I think the Vice Chancellor, Professor Ishwar Bhatt, made a reference to this. One or two speakers also made a reference to this. We have an alternative, which is called the PR system, the proportional representation system. Across the world, if you conduct studies, you will find that there are these two main systems of elections that prevail around the world, either like countries like India, the plurality majority system, the FPTP system is followed, or there are countries which are following the PR system. But let me add a caveat here. There are also countries which are experimenting with combinations of the FPTP with the proportional representation system. And this point was also made by a couple of speakers earlier in the day. Within these broad families are a number of distinct types of electoral systems in operation. As I was just saying a little while ago, there are permutations, there are combinations. These are being followed in different parts of the world. Let me give you a quick list of the permutations and combinations which are being followed, which are being tried, tested, and followed in many parts of the democratic world. You have the alternative vote system, AV system. You have the block vote system, the BV system. The FPTP is one which we are familiar with because we've been following this right from 1952. There is the list PR system, the list proportional representation system, where lists of candidates have to be submitted and are placed before the electorate. There is the MMP system, the mixed member proportion system. I'm not going to any of these details because this is not the occasion to do that. Just to give you an idea of the hybrid nature of electoral systems, there are 5 on this particular page. There are 5 more in this particular page. There is a parallel system. There's the SNTV system. There is the single transferable vote system. There is the 2-round system. And feminists have also joined the fray in making a very powerful argument. You may reform the electoral system, but how would you ensure that women, minority women particularly, are also allowed to participate? Women generally, as well as women belonging to minority communities, because they are subjected to what is called, they're subjected to a twofold kind of discrimination. So all of these systems are either being spoken about or are being practiced in other parts of the world. So I'm placing this before you. I'm not going into details, not necessary at this point of time, but just to give you an overview of the possibilities when one is looking at electoral reform. Let me come to India now. Obviously, largest democracy in the world. But when you take a look at the representation to all communities, given their population, I think there is a problem here. I made a small case study of the Muslim community representation, both in the Lok Sabha and in state legislative assemblies. And I'll give you a couple of tables to prove one point. So far, I was talking of minorities generally, both in India and elsewhere, and making the argument that if your electoral system is excluding either deliberately or otherwise minorities, minority representation, minority voice, can you call that a true democracy? Or do we need to look at democracy afresh? I raised these questions earlier. I'll try to prove my argument by making a little case study of the Muslim community representation in the Lok Sabha and in state legislative assembly. Just 2 tables. I hope you have the patience to look at this. 1952, 2019, I've not looked at all the elections. I've just flagged important elections. 3 columns. Column 2 looks at the percentage of Muslim MPs in the Lok Sabha, and the 3rd column looks at the percentage of population of Muslims in the country. And I request you to take a look at column 2 and column 3 very carefully. 1952, how many Muslim MPs did we have in the Lok Sabha? 4%. What was the percentage of Muslims in the country at that point of time? 10%. Just come down the years, there are ups and downs, 4 to 5 to 6. 1980 was perhaps a major watershed, 9%, 11% of the population. That was perhaps a real defining moment. But what happened subsequently? 1991, 5%, when the Muslims are 12%, 2004, 7%, 13%, 2009, 2014, and the last Lok Sabha election, 2019, when the percentage of Muslim MPs 4.9%, and the population currently is somewhere close to 15%. I'm just giving you this table so that you get a rough idea as far as one minority is concerned. You may ask me questions about why only Muslim minority, are there not other minorities? I'll accept all your arguments. If there's time for questions and answers, I'm not very sure. But there is a point, in case some of you are saying, why have you not looked at other minorities in India and so on? There is a case, and there are studies which are being conducted as far as the representation of other minorities in the Lok Sabha is concerned. But I, for my reasons of my own, I thought this would be indicative of what is happening to the minorities generally in the country. This is one table, Muslim representation in the Lok Sabha. Take a look at this table, which I've also prepared. Muslim representation in state legislative assemblies. I've taken the average from 61 to 2019. Again, 3 columns. States are given the first column, second column, percentage of Muslim MLAs, and the 3rd column is the same as the earlier table, percentage of Muslim population. This proceeds in a what shall I say, in a particular fashion. The states are listed in terms of percentage of Muslim MLAs, which are the largest, and in terms of Muslim population, which is the largest. Assam obviously has a Muslim population of 28% according to statistics, and the percentage of Muslim MLAs in the state legislative assembly is as high as 19%, which I think is to be appreciated. Next would be Kerala, 22% percentage of Muslim population, 17% Muslim MLAs legislative assembly, seems quite okay. And you go progressively downward, West Bengal, UP, Bihar, Karnataka would be important for us to look at, since we are now sitting and talking in Karnataka. Muslim population 11%. How many Muslims in the Karnataka Legislative Assembly today? 3%. Andhra 9% with 3% representation. Rajasthan 8%, 3% representation. And Gujarat, which I think reflects a very, very disturbing figure, according to me, 9% Muslim population, but representation in the Legislative Assembly as low as 2%. Two tables which I'm using as, just to prove my point that when we look at electoral systems and democracies, we also need to look at minorities. And here is a case study of one minority in India, in the Indian diversity. Okay, let me go on. I think these two tables are raising a lot of questions. Obviously, inadequacy of representation is brought out, but I think these questions are raised here. This could be extrapolated to other minorities too. Why do fewer Muslims make it to parliament? Do all parties field Muslim candidates in general elections, both to Lok Sabha and the legislative assemblies? Do voters elect Muslim candidates? What is the role of religious polarization in Muslim underrepresentation in electoral politics? And most importantly, this question, can the scenario be remedied by replacing the FPTP system with a more equitable one? This is the essence of what I wish to share with you this afternoon. And therefore, I think these questions are very important. Those of you who may be a little unhappy about why I've chosen Muslims as a case study, I could replace Muslims with minorities. Let me repeat the questions once again. Why do fewer minorities make it to parliament? Do all parties field minority candidates in state and national elections? Do voters elect minority candidates? What is the role of religious polarization in minority underrepresentation electoral politics? And can this scenario be remedied by replacing the FPTP system with a more equitable one? I think these are serious questions. And as I said earlier, if one is looking at electoral reform, one should begin at looking at the kind of democracy that your electoral system has been propagating. And is it not time to look at the FPTP system, the kind of representation that is happening, and so on and so forth. Having said that, let me come to the third aspect of my paper, where I would draw the attention of this audience to electoral systems in other countries, electoral system reform in other countries. Okay, please note that over the last 25 years or so, and there are enough studies to point this out, over the last quarter of a century, the pace of electoral system reform has dramatically speeded up around the world. And rather than make a sweeping statement and leave you in the dark, I thought I will give you examples. Fiji, which had an FPTP system, has moved from FPTP to a mixture of alternative vote and communal roles. Thailand moved from block vote to a parallel system with proportional representation. These are all based upon statistics and studies, and those of you interested could get in touch with me for details. Ecuador switched from straight list PR system to a parallel system with lists and the block vote. Mongolia moved from block vote to FPTP and then decided to move back again. Indonesia reformed its nationally based PR system to make its electoral districts much smaller. South Africa, there's a task force appointed by the government, and they said that we need to change the system that we're having. You may say these are developing countries. Are only developing countries unhappy with electoral systems? Well, let me also tell you that it's not just these new democracies grappling with electoral reform. A number of established democracies have either reformed their systems already or are seriously engaged in reforming their electoral systems. I'll give you a few examples here. Japan, for example, in 1993, switched from the single non-transferable vote to a parallel system. New Zealand is the best example one can give, which made a dramatic shift from FPTP to a mixed member proportional system. New Zealand, I think, deserves to be looked at very carefully. Likewise, Italy moved to a similar system. It had list PR earlier. Now it has moved to MMP system right from the early 1990s. This is an example of countries around the world, last 25 years or so, which have seriously engaged in electoral reform. Furthermore, a number of other established democracies are considering change. The British House of Commons has long been practicing let me read out the statement. There have long been calls to extend MMPP, mixed member proportional system, beyond Wales, Scotland, London to the British House of Commons. Okay, I think the statement one needs to look at very, very carefully. The MMP system applicable only to Wales, Scotland, London because of the nature of the population there, and in the UK, for a long time they are saying, why should this MMP system only be applicable to Wales, Scotland, etc.? Why not we extend it to the entire British House of Commons? Take a look at Canada. There are growing calls in Canada to change the FPTP system to a more proportional one, and I'm sure you're also familiar with the composition, the composition of the population in Canada, which is undergoing a radical change. Is the USA behind here? No. There is considerable experimentation with alternative electoral systems at the city and state level in the USA. I'm not talking the federal level. I think by and large, there are many problems, but I don't know how easy it would be to change the electoral system at the federal level. But experimentation is going on with the alternative electoral systems at the city level, at the state level in the United States also. In the Netherlands, bills have been proposed to Parliament, which would build in smaller districts to the long-established system of national list PR. So, ladies and gentlemen, this is what I wish to do in the third part of my presentation, where I've just told you that electoral system reform is proceeding in a fairly brisk fashion around the world, both in developing countries, both in new democracies, as well as in established democracies. Effectively, what I'm trying to say is, well, isn't it time that we in India also began to take a look at electoral reform more carefully? I have a couple of more points before I move on to what I wish to say about the kind of democracy we should go in for. New Zealand I referred to earlier. Why has New Zealand given up the FPTP and moved to something more truly democratic? The belief that electoral systems need to better include and represent minority communities. That was the motivating factor in New Zealand, that the FPTP system is not doing justice to minority communities. The composition in percentage of minorities in New Zealand is going up radically, and with the increase in the number of minority communities in New Zealand, it was felt by the wise people there that we need to ensure that our electoral system results in better representation given to these minority communities who we are welcoming into the country in a big way, and who are now playing a big role in the nation. So this example of New Zealand is being quoted as a motivating factor to consider change, consider electoral reform also in other multicultural countries like Britain, Canada, as well as the USA. So at the end of this part of my presentation, I'll take maybe 5 or 10 minutes to complete, 5 minutes at most. It must be acknowledged, perhaps I'm repeating this, but I would like to do it once again, that electoral systems have become an integral part of ensuring minority rights in divided societies. Societies like ours particularly, where which cannot be called homogeneous by any stretch of imagination, where minorities, any number of minorities are there. How do we ensure that minority rights are taken seriously in such societies? They are the easiest way. I mean, if you have systems, electoral systems that take into account the problems, electoral systems that acknowledge the fact that something needs to be done to ensure foundational legislative inclusion of these minorities within these systems, I think we'll be opening our minds much more to what are called better power sharing arrangements, which can happen in our countries. Well-crafted electoral systems can minimize hostilities, and again, this is where I'm juxtaposing the present with a normative statement that when we are putting the minorities in a situation where they are being othered, a situation where there is a kind of phobia against minorities, a situation where the minorities are feeling so hopeless, representation also not happening the way they could, how can the voices of minorities be actually heard? How can how can the concerns of minorities be reflected in policy? And how can we make a change in what is happening, what we see happening around us nowadays? So I would like to read out this particular statement. I'd like you to read this also very carefully. I'm convinced that if we have a well-devised electoral system, a well-thought-out electoral system, one can minimize hostilities in potentially dangerous situations of majority-minority polarization, which is happening in many places across the world, but which worries me most today is what is happening in India, and that, broadly speaking, is majority-minority polarization. How do we deal with it? I think all of us should put our heads together. How do we understand this polarization? How do we understand this othering of certain minority communities? How do we get our youngsters to take a different look at this kind of a majority-minority polarization? And are there systemic reforms that one can do in order to address this particular scenario at one particular level? So as I said earlier, if our democracy today seems to be in the grip of this kind of a polarization, and since we're talking today of electoral reform, I think that electoral reform can make a difference to the kind of polarization and consequences that we are witnessing here. And this is where I finally come to the last part of my paper, building up a case for consociational democracy. The kind of democracy that we have, as I've been saying earlier, is not the kind of democracy that should be practiced in multi-ethnic, diverse societies like ours. The kind of democracy that we're practicing is nothing but a majoritarian democracy. If you look at the electoral system, and if you look at the FPTP system, it's very obvious that we are continuing to believe in, express our faith in majoritarian democracy. Is it time to take a look at another kind of democracy? And here I'm placing before you the need for consociational democracy. Who propounded this first? This is a popular power sharing model, the consociational model, championed by Aaron Leijhart, a Dutch-American, distinguished Dutch-American political scientist. His writings on the subject are rich And I would advise you to take a look at his writings, because his writings seem to show the way forward, especially in societies which are facing this kind of polarization. What is consociationalism? It's a form of democracy which seeks to regulate the sharing of power in a state that comprises diverse societies. And what do we mean by diverse societies? Where there are distinct ethnic, religious, political, national, and linguistic groups. And that is the richness of India that we were celebrating till very recently. That diversity, which we used to celebrate till very recently, when that is under threat, is there any way out of this mess that we seem to have let ourselves into? Arend Leihart is telling us there is a kind of democracy called consociationalism or consociational democracy. Consociational democracy stands in sharp contrast, as I've been telling you, to the concept of majoritarian democracy. Consociationalism seeks to avoid the destabilizing byproducts of winner-take-all majoritarian democracy. That's what FPTP is all about, winner-take-all. How stabilizing is that system? As I said earlier, it's convenient, it's simple, it's easy. But then, is this a kind of democracy, winner-take-all, majoritarian democracy, that we require in this country where the minorities are under siege? Consociationalism guarantees the leaders of all significant groups in society a direct stake in political decision making. Consociationalism prioritizes cooperation and the sharing of power between political elites. The topic is rich, the concept is rich. I don't have time to go into all the aspects, but it fascinates me that we have a term like this, which is telling us, which is showing us the way out of the kind of scenario that we are currently in. How does it work? When group leaders are deliberately empowered to govern together, the group loyalties that formerly stoked violent conflicts are now channeled into resource allocation instead. And what is the end goal of this kind of democracy or this kind of an ism? Consociationalism's end goal is stability based on post-election intergroup accommodation. In theory, there's a lot of literature which we need to go into if we are convinced that this kind of democracy is what we require, and that if we are to do electoral reform, perhaps we need to look at the kind of democracy that the FPTP has brought into force. In India, I think it is time to recognize that minorities have the right to influence the formation and implementation of public policy, and equally to be represented by their own kinsmen in representative bodies. This is what I am convinced. I'm also stating this at the end, that if our political system is to be truly democratic, it must allow minorities a voice of their own to articulate their distinct concerns, to seek redress for their concerns, their problems, and to lay the basis for the establishment of a new kind of democracy called consociational democracy. Having said all that, let me finally end by placing before you a note of caution. Is there a model of consociational democracy that India can follow? And this is my view on this particular question, in answer to this particular question. When designing an appropriate electoral system that addresses the needs of minorities, the case context should determine the decision that we take. Okay, broadly we can agree on consociational democracy, but then we need to decide on what kind of consociational democracy we wish to follow. And there I'm stating that we have to be very careful. The capacity of minority representatives to gain office, to gain influence under various electoral systems is conditioned by a whole lot of factors. And we need to keep these factors in mind. We need to take history into account, demography into account, communities into account, religion into account. We can't it's not easy. What I'm saying is, it's not easy. There's no simple model that we can follow, that we can, submit to somebody and say, let's follow this model of consociational electoral democracy. It's not so easy, because the redesign of electoral systems requires a clear understanding of the situation of all minorities in the country. I'm sure some of you, if the time for questions, would ask me, well, can we include all minorities? And there's so many minorities, apart from the 4 or 5 leading minorities. There are so many other minorities. How is it possible to bring all of them, give all of them representation, and so on and so forth? So it's not as easy as one may think it to be. You have to look at the numbers of all the minorities, the geographical spread, levels of literacy. You have to look at minority women too. You have to look at languages. There's a whole lot of issues need to be kept into account. It's not going to be easy, but can we initiate this process is a question that I'm asking here. I'm stating that electoral systems should be designed to be appropriate to the particular needs of society and to all minorities within it. And when we use the term minorities, I think we cannot leave out the smaller minorities in the discussion on electoral reform or in the discussion of the kind of democracy that we are talking about. This is my last slide, ladies and gentlemen. I think there is need for a national debate on the pros and cons of a consociational democratic model for India before we proceed with electoral engineering. And this is where I am placing a responsibility upon Dr. Chidanand Patil. He heads the Research Center in Democracy and Constitutional Government in the Karnataka State Law University, Hubli. And I'm hoping that Dr. Chidanand Patil will take the initiative to initiate some kind of a debate on the kind of democratic model that we're currently following. As I said, majority democratic model. Does it take care of the interests of everybody? And if it does not, how do we reform this? In electoral reform, can we look at an alternative democratic model called the consociational democratic model? I'm raising several issues. I'm not sure there's time for questions, but I'm open for a discussion on this particular issue. Thank you. Thank you very much.
Thank you very much, sir. That was very great discourse and very pleasant assignment that you have recommended also. Thank you.
ಪ್ರಶ್ನೆಗಳಿಗೆ ಅವಕಾಶ ಇದೆಯಾ ಅಥವಾ ಕ್ಲೋಸ್ ಮಾಡೋಣ? It's been a long morning. I leave it to you, sir.
Yeah, we will close, sir.
Okay, fine.
Yes, sir.
Thank you so much, everyone. We're going to have a short break right now. After that, everybody can rejoin at 2:30 for paper presentations.
Okay. Thank you, Shraddha.
Sir, thank you very much, sir. Professor Jeevan Kumar.
Thank you.
We are really benefited by your address, and the association with Law University will continue, sir.
I hope so too. Thank you. Thank you for inviting me, and I enjoyed speaking to all of you.
Sir. Close it. So please, all of you log in for paper presentation at 2:30, and we adjourn till then. Thank you very much. Now close
I, Hinamika Deshmukh, student KSLU's Law School, take this immense pleasure in welcoming you all to the session of paper presentation of today's national webinar. Now, I would like to introduce our today's chairperson, Professor C.S. Patil, Center Head, Center for Research in Democracy and Constitutional Government. Welcome, sir. Before beginning, kindly note that the timing given for each presenter will be 7 to 10 minutes each. I repeat, 7 to 10 minutes each.
Nilambika, you have to switch on your mic.
I'm so sorry, sir.
Yeah.
Am I audible now, sir?
Yes.
So to begin with our first presenter, that is Mr. Ashray Yash Chakravarti, Research Scholar, Department of Studies and Research in Law, University of Mysore, and Professor Dr. Ramesh, Dean and Chairman, Department of Studies and Research in Law, University of Mysore, on the topic, a critical analysis on the impact of social media on Lok Sabha elections 2019.
Yes, am I audible, sir?
Yes, yes.
So I have to share the screen now.
Yeah.
Yeah. I think the presentation is visible. The PPT is visible.
Yes, yes, it is visible.
So my good afternoon, everyone. My respected chair, my dear colleagues, and my dear friends. My topic is on the critical analysis on the impact of social media on Lok Sabha elections. So when I should start with the introduction part where it all starts from the 2014 elections, where genuinely the social media had impact on the elections, and political party not parties, a party started invoking the social media in people's mind to reach the people, to be precise. Next, obviously, social media was started to connect people around the globe. For example, the CEO of Facebook, Mr. Mark Zuckerberg, had said, I created this platform only to connect the people online from various parts of the world. So he was successful in that, to connecting the people. And most importantly, in the perception of the election, this social media was used to some extent properly, and some it or it fell into some wrong hands as well. So next, so in 2019 elections, the election commission had some regulations on this marketing or canvassing on social media. So it directly links with the US presidential elections in 2008, how Barack Obama had campaigned his elections. So there was a word called dog whistle. So he used to campaign on WhatsApp and text messages regarding the opposite political parties leaders, his weakness or whatever it is. So he used to speak about the keywords of those messages, so that the people used to get connected with the fact. So this was used as a weapon, or it might be one of his strategies to win the elections. So, and notwithstanding Trump's victory in 2016, it is the most important case study which we come across in social media impacting on the elections. A Russian company, so advertising company or marketing company, was given the in charge to campaign on his behalf. He is only campaigning. This company was helping him. just like in the projected areas, they used to the news feeds in those areas were only pro-Trumps. For example, wherever he has won majority of the votes, in those places where his vote was confirmed, he used to feed the information to that company so that pro-Trump's post used to get in their news feeds on Facebook. So he had a very good campaign and won the 2016 elections. Next, how would social media and elections come hand to hand here? As you know, technology is in our hands. Only the medium of technology we are meeting in this virtual meeting here. So it is an indispensable communication tool, and it encourages the social media users to invest in their thoughts in politics, and it enables the cost-effective data collection and analysis in less human effort. To collect the data, if we go back to 90s, to collect the data, how many voters are there, they used to go manually with a pen and paper. Now a Google form will do everything, because almost 80% of the population has a smartphone in their houses. One or the other person has a smartphone. This was used by the used in the Indian politics, and they depended upon that, using social media just to connect with the people and say what all they're doing. Is it good or bad? It's up to the people and their opinion. So whatever it is, first they would share in the social media so that they would get some thoughts from the people. Due to this process, a new statesman who arose in 2014. We all know about it, so I'll not go more on the political aspect of that. So the most important here, that is negative campaigning. So negative campaigning also includes hate speech and other aspects which would directly affect a political leader's reputation and his fame. So this comes under the pre-election campaign, or what they call the political leaders as a conspiracy. There is a report saying that political parties shedding their finances to the political advertising in their social media, especially on Facebook and Instagram as well, because Facebook has converted into a name called Meta. So they are going for a metaverse. So WhatsApp, Facebook, and Instagram are under one umbrella. So there was a predictability result in 2016 election in US, and Trump defeated Hillary Clinton, and you know how surprising it was. So there are negative campaigning in India as well, and the provisions of Indian law goes as there is a repealed provision of Information Technology Act, that is Section 66A of the Information Technology Act, which directly links to the Shreya Singhals case, where it was repealed, and affecting the Article 19(1)(a), and also there is a reasonable restriction under Article 19(1)(2), Clause 2. And in IPC as well, there are many protections for negative campaigning and any defaming a person's or a political leader's fame here. Article 295(a), intentionally insulting a person's religion or belief. 153(a), promoting hostility among people. 499, that is slander. And 505, that is statement leading to public mischief. Section 506, that is criminal threat. Section 124(a), which is yesterday updated news, was they have put on hold the Honorable Supreme Court of India and not to register new cases under the sedition. So something new and something big is coming from the side of the government for the protection of its reputation. Next, tasks in 2019 election. This is the crux of this presentation, where model code of conduct was issued to the social media platforms. So in social media platforms, as we know, Indian laws are not that much, they have not got hold of that, but some of the regulation they can achieve, they have achieved, so that there'll be a fair elections can be conducted. So there were three nodal officers. Nodal officers were appointed to ensure the security of the social media during the elections. So you know how rampant was the hate speech and other defaming tasks were taken up by almost all political parties without any prejudice here. There were a lot of such kind of stuffs, and election commission had done its duty to its best possible way to protect that. So there are various steps taken by the social media companies to ensure safer elections. First one is Facebook had launched the exclusive feature in its named that candidate connect. So there was a feature on Facebook. If you rewind back on 2019 as Lok Sabha elections, there was an exclusive feature named in the Facebook social media platform, that is Candidate Connect, which allows the Lok Sabha candidate to record their election manifesto in a 20-second video, so that they would visually express their manifestos and not go against it. And second one, the same in the same platform, Facebook had planned to start an operation in Delhi, which will also works with the offices of Menlo Park, Dublin, and also Singapore to monitor the election content. So before explaining this, I would give a historical perspective on it, where the Russian company, the same Russian company which had supported for the Trump's victory, was consulted by the various political parties in India as well. So just to control that, the flow of the wrong publicity, Facebook had started its center in Delhi, Dublin, Menlo Park, and Singapore. And the third aspect is WhatsApp had introduced telephonic tip line for its user to report misleading content and fake news. Still, this feature is there on WhatsApp. If you find any this fake news or any diverting facts, you can go to the WhatsApp website and complain about it regarding a fake news ad or misleading content. The fourth one is the Twitter, which is also called as a micro blogging platform, expanded its policy where political ads and to have transparency in that. So whatever the ads are given, just like politicians had become a brand at that time, whatever they said that was given advertisement, so they need a justification for that. If your manifesto is such and such thing, are you going to surely do that, or you're just saying or blowing in the wind? So this undertaking was taken by the platforms like Facebook, WhatsApp, and Twitter. So next, in my concluding remarks, India has the largest young population, that is 18 million mobile and internet user in the age group of 18 to 35. In that, the first voters are of 18 to 23, about 10 million people. So there's a great power of young minds here. Social media plays a very important role in shaping people's opinion. So as you know, Article 19(1)(a) enshrines about the freedom of speech and expression. So this is also kind of expressing their thoughts on internet or any social media platforms. Political parties use these social media to stay up to date and have their welfare activities and compete with the rival political parties. Yeah? So I'm speaking in a perspective where if it falls in a right hands, social media is a good platform for political advertisements or political welfare. But if it falls in wrong hands, so you know how dangerous it would be. So it raises the awareness among the urban, rural, about the election, national development, and variety of issues. So it's not only restricted to national policies or election campaigns or any other. So you can extend the extend whatever you can say for any other issues on the society. So if it falls in the right hand, the positive impact, it increases turnouts in the elections. So this would, I would conclude, I would end my presentation here. I would like to thank Karnataka State Law University to giving me the opportunity to present the paper here, and as well as the Center for Research in Democracy and Constitutional Government. I would thank them a lot to who had given me this opportunity to present the paper, and my guide, my guru, Professor Ramesh, Department of Studies in Law, for giving me the inspiration to present this paper and also write an article on this. So I thank everyone here. Thank you so much.
Yeah, Nilambika next.
Thank you, sir.
Gentlemen, you can stop screen sharing.
Yes, sir.
Our next presenter for the day is Srimati Bhagyamma Ji, Assistant Professor of Law, Sharada Vilas Law College, Mysuru, and Ms. Shreya Gopi, second year LLM student of Studies and Research in Law University of Mysuru, on the topic Curbing the Electoral Discrepancies, a special reference to the Election Laws Amendment Bill 2021.
Ma'am, I want to share the screen.
Yeah, you can do that.
Good afternoon to all the dignitaries and the participants. Title of our paper for today's seminar presentation is Curbing the Electoral Discrepancies, a special reference to the Election Laws Amendment Bill 2021. It is authored by Srimati Bhagyamma Ji, Assistant Professor at Sharada Vilas Law College. Myself being the co-author of this paper, I am Shreya Gopi, studying LLM at University of Mysore. To quote the legendary Chief Election Commissioner of India, T.N. Sheshan, good government is not an accident. On August 15, 1947, nation obtained independence after a centuries of colonial rule and chose to be a largest democratic country in the world, with the motto of the people, by the people, for the people. It is the right of the people of this country to vote and elect the member of state legislature and for the parliament. For that, country needs a proper governance. Governance in India is as follows. It is based on the British Westminster system of parliament. Prime Minister will be the head of the state and elected by the parliament. It is followed by and elected state legislature. In grassroots level, this is elected to conduct rule. Those rules are political interference. A set of laws is required to govern the elections. There should be a redressal committee. Election commission will implement the laws. India has its own election committee. It prepares the electoral rolls and other issuing a special directions, etc. This commission includes electoral registration officers, returning officers, presiding officers, candidates, polling agents, and counting agents. And who will frame these laws? Parliament will frame the laws for presidential election and state legislature election. State legislature will draft the laws for pertaining to the election of municipalities and panchayat. And as per the rules, there should be a redressal committee. To solve the dispute related to the president election, it is handled by Supreme Court. Any dispute which is related to the parliament and state legislature, it is handled by State High Court with the provision of appeal with it. There are acts and rules relating to the election laws, that is Presidential and Vice Presidential Election Act 1952 and Presidential and Vice Presidential Election Rules 1974, Representation of People's Act 1950, the Registration of Electors Act Rules 1960. Under this, Section 28 provides for the registration of eligible electors and issuance of voter ID cards with the voter's photograph. Representation of People Act 1951. Conduct of Election Rules 1961. To face the election, you need to have one face, that is election symbols. Election symbols are the face of a political party. This order governs the matters for reservation of election symbols for political parties for both national and state elections. It oversees the allotment of symbols to the various candidates that are standing for elections. This order also helped in the resolution of dispute between the splinter groups. And you need to follow the code of conduct. Under Article 324 of our Constitution, the Election Commission of India has right to enforce the Model Code of Conduct, which ensures the elections are free and fair with the participation of every candidate upholding these values. Supreme Court of India held that in Mohinder Singh Gill versus Chief Election Commissioner that Article 324 contains the plenary of powers to ensure the free and fair election, and these are vested in the Election Commission of India, which can take all the necessary steps to achieve the constitutional objective. It is a hard-working body dedicated in increasing the participants of people in an election. Election Laws Amendment Bill 2021. Despite of severe opposition and disturbances, the bill was passed in both the houses. Through the bill, the government is amending both the Representation of the People Act 1950 and 1951. One of the main provisions creates a legal framework to link the electoral roll with the Aadhaar. The new rule imposed the electoral registration officers to ask a person applying for a new voter ID to furnish or that number of Aadhaar card for the purpose of establishing the identity. They can also see the Aadhaar numbers from registered voters to check for a duplication by the government. It has insisted that furnishing Aadhaar is voluntary. The wording of the bill raises the doubts about such assertions. It says that no one shall be denied of registration and no entry shall be deleted from the electoral roll due to the person's inability to furnish the Aadhaar number. Crimes have been made by the provisions of the bill. Later, Supreme Court ruled in 2015 to limit the use of Aadhaar to financial and welfare benefits. In 2018, voter ID cards were linked with the other database in Telangana and Andhra Pradesh. Later, names of at least 50 lakh voters went missing from the electoral rolls and forced the government to roll back the decision. Apart from this, the bill also seeks to designate the April 1st, July 1st, and October 1st as qualifying dates in addition to the January 1st for the enrollment of 18 years old as the voters. And that amendment leads to the amendment to the Representation of People's Act 1950. It allows the section 22, it allows the linking of electoral roll data with the Aadhaar system. Section 14 allow having a 4 qualifying dates for eligible people to register as a voters. Section 20 and Section 60 of the Representation of People Act 1950 and 51 respectively allows the elections to become a gender neutral for the service voters. It will replace the word wife of service voters with the word spouse, making the statute gender neutral. Conclusion. This bill is criticized for violating the privacy of person by linking it with the Aadhaar card, which goes against the Puttaswamy judgment, in which right to privacy was declared as fundamental right. In another ruling, it limits the use of Aadhaar card for financial and welfare schemes. The provisions of the bill must be carefully scrutinized by appropriate standing committee. Views must be taken by the standing committee in consideration of the bill, and due consultation must be held for widened views so as strengthen the parliamentary democracy in the country. Thank you.
Thank you. Up next, we have Mr. Arijit Chaudhary, second year BA LLB Honours, Reva University, and Ms. Sona Vajrala, fifth year BA LLB Honours, Reva University, Bangalore, on the topic Politics of Defection in India, the Intent and the Impact.
Sir, Arijit is not present.
They are there. Then the co-author also is not there. Sona Vajrala. Then you please call next Neelambika.
Yes, sir. We'll move on to the next speaker. Mr. Pramath Adiga, lecturer, MES Law College, Sirsi, on the topic prioritization of winnability over integrity of the candidates, a bane to democracy.
Yes, Pramath. Pramath, you have to unmute yourself. No, you have to unmute. Your mic is off. No, you are not audible. No.
ಸರ್ ಕೇಳುತ್ತಾ?
ಈಗ ಕೇಳ್ತಾ ಇದೆ.
ಸರಿ, ಅದು ಅದೇ ಸರಿ ಇಲ್ಲ ಬಿಡಿ. ಅದು ನಮ್ಗೆ ಹಿಂಗೆ ಓಪನ್ ಆದ್ರೆ ಬೆಸ್ಟ್. Good afternoon, sir. Good afternoon. When I saw the topic that you had given in the brochure, I selected this topic thinking the thinkable capacity of our sir, C.S. Patil sir. So I thought that no one would select this topic because it is some peculiar topic, and it is very difficult to get material on this aspect. That is why I thought that I should deal with this aspect as a priority one, sir. So it is one of the good topic as I have selected, sir, and it is an opportunity to me to select the topic and grace this occasion, sir. The first thing I would like to state is Rajendra Prasad's statement, sir. If the people who are elected are men of character and integrity, then they would be capable of making the best even out of the defective constitution. That means when we select those persons who are having good character and integrity, it is not the constitution, it is the people who rule them having good character and integrity. Definitely it gives a shining to our constitution, whatever the defect it may have. So that is the one thing he has stated in the Constitutional Assembly debate way back in 1949, sir. So this is what the aspect gives us a boost to think that our election system should be of such a nature that the candidate whom we elect must have an integrity of his own. And when we refer the word text, what we find is there are mainly two types of governance. One is of autocratic government and partly pre-governance. So in partly pre-governance and autocratic governments, civilian become a casualty because they don't have a free hand in selecting the candidate whom they prefer to represent. That's the problem they face in the autocratic and partly pre-governance. India may have a pre-governance, but the factuality that we find in the present context does not suit the main aim of the constitutional claimers. So we have taken it to somewhere else so that we have distracted from the real objective of the constitution. So I don't want to deal with the essential element of democratic governance and general qualification, disqualification, and special grounds for disqualification under Representation of People Act, Civil Rights Protection Act, Customs Act, Unlawful Activities Prevention Act, and Narcotic Drugs and Psychotropic Substance Act and Prevention of Corruption Act. And I just want to light upon one of the point being highlighted by our morning speaker, Sri Vijay Kumar sir. So he has mentioned two things there. That is, a candidate who is convicted with a fine could not contest in the election for a period of 6 years from the date of conviction. And the candidate who got convicted with imprisonment could not contest in the election for the period of 6 years since his release or her release. And one more point here that out is there is election guidelines. So what it says, if a person who is convicted is released on bail and his appeal is pending for disposal, he is not entitled to contest in the election as per guidelines issued by the Election Commission of India. So that means this guidelines has removed leeway available to a person to contest in the election up to the time of exhaustion of all judicial solutions from the lower court to the Supreme Court of India. And what type of ideological conflict that we find in relation to the winnability and integrity factor in selection of the candidate to contest in the election. In India, we find 7 factors. One is commitment to a party. A person who is selected as a candidate to contest in the election, he is not examined from the point of view of integrity that he possesses towards the people who are required to elect them. They think more about how he is committed to the party in one or the other way. So this is where we commit a first mistake in leaving out the integrity element in the candidate who is going to contest in the election. And the second one is charisma of a candidate. Charisma of the candidate is determined on the basis of his caste, community, status, and social backup. So when you try to compare the capability of the candidate on the basis of caste factor, community factor, or status or social backup, how can you determine the integrity element of such type of candidate? So thereby, what we lose is people don't have the candidate whom they intend to serve them. And they give prominence to that charisma. That means particular caste elect them, not because he is going to serve them, but he will benefit the caste or community. And another thing is financial capacity. So what we find here is a candidate who wants to contest in the election is allowed to have a ticket of a political party, not on the basis of his ability, but on the basis of financial capacity that he possesses. When you concentrate on his financial capacity, he wants something in return for what he incurs at the time of election. So that's the mistake he commits. And another thing is no role in policy making. There is a big example in the form of a former prime minister and a former president. I don't want to disclose their name. And they got elected to the Rajya Sabha. And it does not mean that they are not capable of holding a position. They are capable of holding a position, but they don't have the capacity to get themselves elected from the people in a direct way. That means the person who is in a position to frame up the policy is not in a position to get himself elected from the people. So that's another mistake that we find in the present election system. And then upper hand of political elites at the time of selection of the candidate, senior member or few elected members or the senior party members elect the such candidate who influences them or grease the palm of them. So that is the mistake they will do. And then threat of whip. And whenever the party gives a ticket to a candidate, what they do, they just try to whip the candidate that so he should not dissent from whatever policy or whatever direction they issue. So if at all he try to dissent from whatever direction they give, then they don't issue ticket to him. And then no preference to active involvement. So they don't give preference to the active involvement in the sense that if a candidate is capable of involving in the election or other activities, then the person who is already in the position, they think that if he is allowed to have a ticket, if he gets elected, then they may lose the position. So that is the fear they have. That is why they don't allow him to have a ticket, and thereby a valuable candidate is denied from getting the ticket. And then another thing is that interested to stabilize one's position. A person who gets elected in the election thinks about keeping that position for 20 years or 30 years. As an employee, we are in a position to get the pension only after 15 years. But in case of the representative of the people, they are in a position to get the pension immediately after completion of one term. And they are not thinking about that pension, but they are thinking of holding up the position forever. That means they don't want to lose the position once they get it. And if they lose it, they think that they may not get the respect of the people. So that is what the way we think that integrity has become a casualty in the context of the comparison with the ideological ideology that we have concerning the election in India. And what will be the effect of denial of or degrading of the integrity in India? The increase in the money power and muscle power. And the second one is, as per the survey of Centre for Study of Developing Society Association for Democratic Reform 2018, nearly 34% of the candidates are accused with criminal charges. So when 34% of the candidates are accused of criminal charges, then what is the guarantee that we are going to have a law against these criminal activities? And then another thing is sharp caste division and social division. That means they try to divide the people in the name of the caste, in the name of the community, and on different social causes. So when they try to divide the people in the name of a caste or a social division, in the end, what happens? They are the creator of the problem, and they try to give a solution to such type of problem. And thereby they neglect the real problem of the people of India or the people who have elected them. And they lack accountability. That means they are not worried about how many assurance they have filled in the particular term. And they are thinking about how to create an impression without doing anything. So this type of attitude we may find in our candidates. And what is the judicial observation to sideline the winnability factor and uphold the integrity factor? I just want to take one or two cases in this behalf. In Lily Thomas case, the court had held that the convicted MP or MLA will get disqualified with immediate effect. That means they should not be allowed to contest the election, though their appeal is pending before the higher court. This is what the verdict that we find in the Lily Thomas case. And one more important verdict that we find in the People's Union for Civil Liberty. So why this case is very important? Because the court has directed the Election Commission to include nota option in the electronic machine. Machine. That means once they make use of this nota, it is once they make use of this nota, what happens? The person who has elected them gives a warning to the party that even though you have chosen your own candidate, we are not ready to accept him. And a situation should come in such a way that no candidate selected by the party should get elected, and entire nota should be passed to a particular candidate. Thereby, we should teach them a lesson that people's verdict is more than the candidate they have selected for the purpose of contesting in the election. And then Union of India versus Association for Democratic Reforms. So this verdict is very important from the three factors. That means it has permitted to submit the affidavit stating their prior financial position, criminal background, and educational qualification. That means these three factors are very important from the point of view of the people who are required to elect the candidate in the election. So that is why I think this case is very important. And one more case is Resurgence India versus Election Commission of India, wherein the court held that returning officer can reject nomination paper of a candidate for non-disclosure and suppression of information, including that of assets and criminal background. That means returning officer may take a clear action against such candidate who has failed to submit their criminal records and relevant information at the time of submission of his application. So what is the positive effect that we find from the judicial observation? One is provide significance to the educational qualification in selection of candidate. And the second one is provide transparency in debt clearance by giving encouragement to submit no dues certificate, and then provide true picture of assets of candidate and his family members before she goes before the electorate, and provide an option to know moral uprightness of the candidate by forceful disclosure of criminal charges against him or her. Provide background details of the candidate as to his/her conviction, acquittal, criminal charge filed in the past. Provide wide participation of people by giving option to cast negative vote, that means nota, and to foster fairness in electioneering purpose. And what type of constitutional hurdles that we find and statutory hurdles that we find in enforcement of the judicial observation? One is constantly changing the position which are considered as part of the office of profit by the parliament. And then one more thing is that under entry 72 of the list 1 of schedule 7 of the Constitution of India, Parliament has the legislative power to make legislation on election concerning Parliament and the state legislature. That means it has full-fledged power to make a legislation on election. The moment judiciary passes any verdict, automatically they bring a legislation to nullify the scope of the judicial observation. And another thing is that in entry 97 of list 1 of schedule 7 of the Constitution of India, Parliament has a residuary power. That means unmindful of the matter that we find in entry 72, we also find full-fledged power in entry 97 of list 1 of schedule 7 of the Constitution of India. And one more defect that we find in the statutory provision given in the Representation of People Act is section 62(5) of it. So it provides that it disqualifies an elector from the right to vote, but not the person contesting in the election, because section 2(e) of Representation of People Act defines elector as a person who is in the electoral role of the constituency. That means it tries to make a difference between elector and the voter. So here a voter may be a voter, but if you want to become an elector, then your name there be in the election roll. So this is what the way we find constitutional and statutory hurdle while disqualifying the candidate contesting in the election. So what are the suggestions I may propose to remove this type of winnability factor and giving importance to the integrity factor is empower Election Commission of India to deregister political party which gives ticket to candidates with criminal background. In the first way, they should be removed, and provide constant awareness as to the significance of right to vote to voters and its hijacking by criminally besmirched candidate. So that should be done, and bar a candidate from contesting in election who is involved in heinous crime, and need to bring political party within rubric of right to information, need to apply principles in relation to collection of funds and electioneering very strictly, need to limit candidate to incur election expenses strictly within the permissible limit as fixed under Rule 90 of the Conduct of Election Rules 1961, and need to deem excess expenses incurred by the candidate as a corrupt practice under Section 123(6) of Representation of People Act, need to find real source of revenue generation or funding either by supporter or sympathizer or both, and seek explanation and reasons behind such contribution and funding, and then need to revise election expense very often to avoid excuses being sought in that behalf by the parties. And the moment the matter comes before the competent trial court, that the candidate shall be disqualified once the court frames the charges against him. That means while framing the charge, the court is not going to charge it unless it has substantial materials in proof of it. So that is why that should be done. And conclusively, I want to quote the statement of Dr. B.R. Ambedkar. How good a constitution may be, but it will be turned into a bad if it is entrusted to be worked by a bad lot. How bad a constitution may be, but it will be turned into good if it is entrusted to be worked by good lot. So if we do it, definitely we may have a good constitution and good ruler and a good governance. Thank you, sir.
Thank you so much, sir. Up next, we have Ms. Akhila Yogesh Prabhu, Research Assistant, CRDCG KSLU Hubballi, on the topic, compulsory voting, desirable but not practical.
Thank you, Nilanka. Good afternoon, everyone. My topic for presentation is compulsory voting, desirable but not practical. The founding fathers of India conceived of representative parliamentary democracy suited to Indian ethos, background, and needs. They envisaged equal participation of all the adult citizens in the democratic process without any discrimination. One of the most important features of democratic polity is election at regular intervals. Free and fair elections are considered as basic feature of Indian Constitution. It is through election that people in democracy participate in the public affairs and express their will. It is again through election that power changes hands in a peaceful and orderly manner in a democracy. Going by India's record in this regard, periodic election as a means of smooth transfer of power have been a regular and successful feature of Indian democracy in the past 75 years. As the biggest democracy in the world, huge elections are held in India. At general election, millions of electorates goes to the poll to elect their representatives. In spite of all these things, Indian democracy is not flawless. Our electoral process is suffering from many problems like money power, muscle power, corruption, criminals, etc. Because of these reasons, voting percentage in the election is continuously declining. For example, India has so far had 17 parliamentary elections, in all of which around 40 to 50% voters did not exercise their right to vote. Voters' interest is continuously decreasing in the elections. This is a grave concern for Indian democracy because Indian democracy is based on the elections. Thus, it is very important to increase the voting percentage and keep our democracy alive. There are many ways to increase voting percentage. Compulsory or mandatory voting is one among them. Therefore, to know more about compulsory voting, this paper deals with meaning of compulsory voting in India, compulsory voting in other countries, arguments for and against compulsory voting, and how it is desirable but not practical to implement in India. Let me begin with the meaning of compulsory voting. Compulsory voting means it is an obligation to vote. It means it shall be the duty of a voter to cast his vote at elections, failing which he will be liable to penalty, or he will be declared as defaulter voter. Compulsory voting is a system in which electors are obliged to vote in elections or attend a polling place on voting day. Compulsory voting is not a new concept. Some of the countries that introduced the mandatory voting laws very long back, for example, Belgium in 1892, Argentina in 1914, and Australia in 1924. If we look at the history of compulsory voting in India, the concept of compulsory voting was first considered by Parliament during the enactment of Representation of Peoples Act in 1950. That time, because of practical difficulties in implementation, it was rejected. Then in 1990, the Dinesh Goswami Committee considered the compulsory voting to increase voter turnouts, but the committee rejected the idea based on implementation difficulties involved in it. Subsequently, in 2001, the consultation paper of the National Commission to Review the Working of Constitution on Electoral Reforms again considered and rejected the proposal for compulsory voting. Pursuant to this, the issue of compulsory voting was discussed in the Parliament in 2004, 2009, 2012, 2015, and very recently in 2019, when private members introduced a bill to that effect. But till now, bill has not been passed in the Parliament. Meanwhile, the Gujarat Local Authorities Laws Amendment Act 2009 was passed, introducing compulsory voting at local level elections such as municipalities, municipal corporations, and panchayat level. But in 2018, the Gujarat High Court stayed the legislation, observing that right to vote itself provides the right to refrain from the voting. The court issued notice to the government and State Election Commission in this matter. Thus, after many efforts also, voting is not yet made compulsory in India. If we see the position of voting in other compulsory voting position in other countries, compulsory voting is currently presented in the statutes books in 28 countries, but it does not give true picture of the level of enforcement, which is even lower. Thus, most studies estimate that around 14 countries currently enforce compulsory voting provisions in their country. So these includes many small countries such as Belgium, Liechtenstein, Luxembourg, and other countries such as Australia, Brazil, Singapore, Peru, Uruguay. Some countries abolished compulsory voting from their system. For instance, Netherlands in 1967, Italy in 1993, Austria in 2004, Chile in 2012, and Fiji in 2014. Some countries such as Liechtenstein and Greece have moved from a strict to non-strict or non-enforcement compulsory voting laws, and Egypt, Mexico, Paraguay, and Thailand have stopped enforcing it. Amongst the countries still enforcing compulsory voting provision, most impose strict penalties. Thus, in Peru, voters must carry their stamped voting card to obtain certain goods and social services from the public offices. In Brazil, failure to vote result in the imposition of fine. Failure to pay the fine, however, entitles the state to impose a range of sanctions, including being prohibited from applying for any public position, from receiving a salary from a public post, to apply for certain professional exams, and from obtaining a passport, identity card, certain types of loans, and teaching licenses in public educational institutions. But even apart from that, non-voters might find it difficult to get jobs in public sector, or if they are civil servants, they will be disentitled to get any promotions. So this is the position of compulsory voting in other countries. If you see the merits of compulsory voting system confers a higher degree of political legitimacy because they result in increased voter turnout. The victorious candidate represents a majority of the population, and compulsory voting may encourage voters to research the candidate's political position more thoroughly. It highlights the improvement in public awareness and financial benefits because resources generally utilized in convincing people to vote instead of focusing on campaigning on substantive issues. If we see the disadvantages of compulsory voting, any compulsion affects the freedom of an individual. Voting may be seen as civic right rather than as civic duty. Compulsory voting may infringe other rights also. Some suggest that it is undemocratic to force people to vote as it is an infringement of liberty. These are some disadvantages of the compulsory voting. To conclude, compulsory voting can be a powerful tool for increasing participation in elections, strengthening the unique and valuable role of elections in India. Compulsory voting promotes at least minimal participation from many citizens who would otherwise be politically marginalized. But at the same time, compulsory voting creates a lot of problems. As we have seen the examples of other countries who have made compulsory voting and punishing non-voters by imposing fine or restricting their access to government services and benefits are extremely harsh measures and will not work in Indian context. If the fine is too low, then it will only affect the poor and it will not affect the behavior of the rich. If the fine is too high, in that case also, it is very difficult to pay for the poor and it will not make any difference to rich person. For all these reasons, and comparative examples do not provide any justification for the imposition of compulsory voting in India. Thus, instead of seeking encouragement to compulsion, the government should seek persuasion by education and action, incentive schemes such as tax rebates or financial benefits to voters to boost the electoral participation. Thus, the introduction of compulsory voting in India is desirable, but it is not practical because it is undemocratic, illegitimate, expensive, and it is very difficult to implement. Thank you.
Thank you, ma'am. Up next, we have Mr. K.S. Vivijay Kumar, Assistant Professor of Law, Pest Law College, Mandya, and Research Scholar, DOS in Law, University of Mysore, and Professor Dr. C. Basavaraju, Research Superintendent, Professor of Law, University of Mysore, on the topic, Press Freedom in India, a Critique.
Sir, audible? Hello?
Yeah, you are audible.
Yes, sir. Yes, sir.
You can start.
Yes. Good evening, one and all. Respected Chairperson, Professor C.S. Patil, sir, and all participants, and all various faculties. So my topic is Press Freedom in India, a Critique. So first started by the one quote. Former Prime Minister Rajiv Gandhi says, freedom of press is an article. Freedom of press is an article of faith with a sanctioned by our constitution, validated by 4 decades of the freedom and indispensable to our future as a nation. Yes, the totally 5 important of the component my topic. One is freedom of press on international perspectives. Second one is preamble aspect. Third one is constitutional perspectives related to the freedom of press. And fourth one is legislative privileges related to the freedom of press. And the last one is what are the latest trend related to the judicial provision in the freedom of press under the Indian Constitution. Let us now the first discussion for introduction part of the freedom of press. So speech is a God gift of the mankind, and also the freedom of press means the right to print and publish without any interference from the state or any other public authority. And the freedom of press apply to all types of the printed and broadcast material, including the books, newspapers, magazines, pamphlets, films, and radio and television program. So these are the briefly introduction part of the freedom of press under the Indian Constitution. And let us now the second aspect related to the freedom of press in India. What are the important of the international perspective related to the human right aspect? So the Universal Declaration of Human Rights, called as UDHR, in 1948 was acknowledged to Article 19. UDHR Article 19 is clearly says that everyone has a right to freedom of opinion and expression. The right include freedom of word, opinion without interference, and seek, receive, and import information and ideas that any media and regardless of the forthrights. That is Article 19 of the UDHR. And another aspect, the International Covenant on Civil and Political Rights approved in 1966 and also says that Article 19 of the Covenant clearly says there are two important of the aspect. One is everyone shall have the right to hold opinions without interference. And second one is aspect and also related to the Article 19 of the International Covenant on Civil and Political Rights. Everyone shall be a right to freedom of expression. This right included by the freedom of seek, receive, and impart information and ideas and all kinds. This is the second important of the aspect. Next, Article 17 of UDHR says inviolable right to privacy and personal identity. Article 18 says that right to freedom of thought, belief, religion, and Article 25 says right to participate in the state and social management. So, and also aspect related to the UDHR to put in human rights in there is a right to freedom of speech and press into full effect the role all the state always needed, because a state is responsible to the guarantee of human rights. And also an educational, scientific, and cultural organization that is called as a UNESCO, always in the forefront, the pursuing of the head, the freedom of speech and freedom of press, protecting interest of journalists. Okay. The European Convention of Human Rights says Article 19 says American Convention on Human Rights, the African Charter of Human Rights, and the rights of nation have the acknowledged the right to freedom of speech and the expression. Okay, so these are the main important concept of the international perspective related to the freedom of speech. Okay, and third important of the component is what are the latest provision for related to the freedom of press in the constitutional perspective. So preamble says a constitution ensures to all citizens inter law, liberty and thought, expression, belief, faith, and worship. The constitutional significance of the freedom of speech consists of the preamble of the Constitution, a transport by the fundamental and human rights, Article 19, subclass 1A of the Constitution, called as freedom of speech and expression. And also the main important of the freedom of speech and expression, the main objective adopted by the General Assembly of the United Nations Organization 10th December 1948, and Article 19, every as a right to freedom of opinion and expression with the right to include freedom to hold opinions without interference and to receive, import information, idea that any media regarded less forthright. So the Article 19 of the freedom of speech and expression related to the constitutional perspective, Pandit Jawaharlal Nehru said, I would rather have a completely free press with all the danger involved by the wrong use of the freedom than suspended and regulated by the press. That is opinion for the Pandit Jawaharlal Nehru. And also the main important of the components of the freedom of speech and expression, Article 19 of the Indian Constitution, some reasonable restriction. It clearly says that Article 19 subclass 2 imposed by the reasonable of the restriction. For example, sovereignty and integrity of India, security of the state, friendly relations within the foreign state, public order, decency or morality, or contempt of court, defamation, and incident to an offense. Article 19 subclass 2, it is a restriction imposed by the freedom of speech and the expression. And also, fourth important of the component of the related to the concept, legislative privileges. Article 105 and Article 194 of the Indian Constitution, freedom of rights, privileges related to the member of parliament and state legislature. Article 105 and 194 of the Indian Constitution. For example, freedom of speech in the parliament within the four walls of the freedom of speech and the expression. And also the freedom of from arrest, but only for the civil cases as per the permissible. And third one is right to prohibit by the publication of the proceedings. And fourth one is right to exclude by the stranger, right to regulate by the internal affairs of the houses. So these are a number of parliamentary privileges and immunities guaranteed by the Article 105, 194 of the Indian Constitution related to the provision of the freedom of speech and expression. Means it's a freedom of press. And the last concept is related to the provision of the what are the important of the judicial trend in the freedom of speech and expression. Means it's a freedom of press. So number of cases, for example, in the case of the Indian Express newspaper versus Union of India, so Supreme Court clearly says that in this case, a freedom of press plays a very important role in the democratic of the machinery. The court also in the freedom of press invalidated all laws, administrative action abroad by the freedom. Means the freedom of press is a essential of the element. So this is the one case. And the recent important of the case is related to the Supreme Court 2021 is called as the Chief Election Commission of India versus Vijay Kumar. Is decided by the 2021 is a related case. The Chief Election Commissioner of India versus Vijay Kumar, the Supreme Court clearly says that related to the freedom of speech and expression means it's a press. Supreme Court clearly says that freedom of speech and expression also extend to the reporting the proceedings that happen court, including the oral observation made by the judges. That is one of the important of the latest judgment of the Chief Election Commissioner of India versus Vijay Kumar. And also some suggestion for related to the freedom of press. First suggestion is your freedom of press may be inserted by the specific fundamental rights of the Constitution of India. And second important suggestion is the law must be strengthening the condition of the freedom of press, protect the right to communicate and right to information. Some important of the suggestion. And the last my concluded part related to the provision of the freedom of press. So speech is God is a gift of mankind. Okay. So in case of the father of the nation, Mahatma Gandhi says that the role of journalism should be service. The press is a great power, but just as a unchained torrent of the water submerged the whole country side and devoured by the crop. So uncontrolled when served but also destroyed. And so the main important of the freedom of press is one of the fourth pillar of the Indian Constitution as per the provision of the Indian Constitution. And last provision is the freedom of press means the time is come to the press, the largest democracy of the world, you work with the hand to hand with judiciary for the welfare of the subjective. So these are the my important concept related to the freedom of press. Okay. And thank you for given opportunity, sir, by the behalf of university and also my professor C.S. Patil, sir, and my guru, Professor C. Baswaraju, research superintendent and professor of law, University of Mysore and Mysore, inspiration for paper presentation. Thank you, sir. One and all.
Thank you, sir. Up next, we have Ms. Anita B.M., Research Scholar, Department of Studies and Research in Law, University of Mysore, and Professor Ramesh, Professor of Law, Department of Studies and Research in Law, University of Mysore, on the topic, Critical Analysis of Anti-Defection Law in India.
Good afternoon, everyone, respected chair and fellow paper presenter. I'm Anita, research scholar, Department of Studies and Research in Law, University of Mysore. My topic is a critical analysis of anti-defection law in India. The 52nd Constitutional Amendment Act 1985 added the 10th schedule to the Indian Constitution, popularly known as the Anti-Defection Law. Defecting party members posed a threat to the very foundations of the Indian democracy and the principles that sustained. The amendment aimed at reducing party defections prevalent amongst the members at that time. The law has succeeded in a reasonable manner and has been able to secure party stability to some extent. The schedule mentions the grounds on which a defecting member stands disqualified from his original political party. Initially, the constitutions of India did not have any mentions about the political parties, but gradually, when the multi-party system evolved, there had been defections in the Indian parliamentary system, where there have been a shift of people from one political party to another, which resulted in breaking down of public confidence in a democratic form of government. Defections is desertions by one member of the party of his loyalty towards his political party, or basically it means when an elected representative joins another party without resigning his present party for benefits. This practice of elected members switching the political sides to get office is also known as horse trading. The politicians do make promises to do the things for the benefits of citizens, but oddly fulfill all of them. The main objectives for which the anti-defection laws was introduced in the constitutions was to combat the evil of political defections. Anti-defections is the law by which the persons who do defections are punished according to the rules of the law. A person so found doing defections is disqualified to be a member of parliament or state legislatures. Recommendations of various committees on reforming the anti-defection law. The Dinesh Goswami Committee on Electoral Reforms. Disqualification should be limited to cases where a member voluntarily gives up the membership of his political party, a member abstains from voting or votes contrary to the party, whip in a motions of vote of confidence or motions of no confidence. The issues of disqualification should be decided by the president, governor on the advice of the election commissions. Law commissions, provisions which exempt splits and mergers from disqualifications to be deleted. Pre-poll electoral fronts should be treated as political parties under anti-defection law. Political parties should limit issuance of whips to instances only when the government is in danger. Election commissions decisions under the 10th schedule should be made by the president, governor on the binding advice of the election commissions. Constitutional review commissions. Defectors should be barred from holding public office or any remunerative political post for the durations of the remaining term. The vote cast by the defector to topple a government should be treated as invalid. Important case laws, Kyoto Holohan versus Zaki Hullu and others. Another one case laws, Keshavananda Bharati and others was the state of Kerala. Shri Avtar, one more cases, Shri Avtar Singh versus Shri Kuldeep Singh case laws. One more cases, Shri Rajesh Verma versus Shri Muhammad Shahid. Finally, I would like to conclude my topic. Anti-defection law needed to be amended to be in consonance with current facts and circumstances. Ever since the passing of the anti-defection law in 1985, it aimed at curbing political defections and bringing government stability. Thank you for giving me opportunity, Karnataka State Law University and my guide. Thank you, one and all. Thank you.
Thank you so much. Up next, we have Mr. Sadashivappa MS, Assistant Professor of Law, Vivekananda College of Bangalore, and Dr. M.S. Benjamin, Associate Professor, Department of Studies and Research in Law, University of Mysore, on the topic Representation of Women in Democratic Institutions.
She is not there. Nilambika,
Yes, sir.
you can.
We'll move on to the next presenter. The next presenter will be Mr. K. Mahesh Aditya, Christ Academy Institute of Law, Bangalore, on the topic compulsory voting.
So good afternoon, sir. Am I audible?
Yes, you are audible.
Sir, is my screen visible?
Yes.
Sir.
Good
Good afternoon, revived dignitaries. This is and my fellow participants. This is K. Mahesh Aditya Srivatsan from Christ Academy Institute of Law, studying BA LLB 7th semester. So my paper presentation on today's topic is about compulsory voting. So before going into compulsory voting, so let's just understand what democracy means. So democracy, according to Abraham Lincoln, means of the people, by the people, and for the people. So basically, he defines it as it's a kind of government where all eligible citizens participate equally. So based on this, the sociologist Alfred Deakin has started the concept called democracy in the late 19th century. So he has defined the compulsory voting as a legal obligation to attend at the time of election. So by the meaning of legal obligation, we can understand that the failure to attend the vote will have consequences and punitive penalties. So the main purpose of electoral system to exchange a vote and cash by voters into the parliament, it's a kind of participation which is interlinked with the primary aspect of democracy. And the same has been held in the Mohanlal versus District Magistrate. So unless and until the elections are conducted properly and elections have the particular sanctity, the democracy cannot be achieved. So by this statement, we can say that the elections and democracy is directly linked with each other. So coming to the issues, research problem, the issues with respect to the democratic voting. So voting is generally said to be a civic right rather than duty according to the Indian Constitution. But the People's Representation Act says that compulsory voting is a duty rather than a right. So for example, according to Article 19 of the Indian Constitution, if we say that article freedom of speech and expression gives right to speech, we also have right not to speech. So this is the major criticism according to legal jurists, which say that when people may exercise right, they also compelled not to do it. For example, if we have right to freedom of speech and expression, we also have right to remain silent. So, and also the other criticism arises, like there are also people who doesn't have knowledge about candidate. Hence, it also disrupts the quantity and breaks the sanctity of elections. Also, even through electoral compulsory voting is enforced with penalties. So this is the major drawback for the poor people who is casting their vote from the local areas or rural areas. So these are the two research areas which I did my research. Is there any direct connection or link between the compulsory voting and the democracy? So the process of election itself that represents democracy. It's because the peoples and candidates are choosing their candidates who are contesting for the elections, and they are also choosing leaders of their choice. So the major participation which directly represents the democracy. So democracy can be entrusted, as I said before in the introduction part, can be entrusted only if the standard of election and the sanctity can be maintained properly. And the second topic is how to enforce the compulsory voting, or are there any ways which we can enforce compulsory voting? So penalties for failing compulsory voting should not be limited to fine and sanctions. So if we go through the countries like Belgium and Singapore, fail to vote will be subjected to disfranchisement. So election is a direct representation of democracy. So it's directly represents democracy. So penalties for failing the vote should be, so for example, in the countries like Greece and Peru, the goods and services provided by the public officers will be utterly cancelled. And also the citizenship will be removed. And if you go to the Bolivian countries, the salary for the period of 3 months will be denied. So coming to the advantages of compulsory voting. So compulsory voting prevents disparagement of socially advantaged people. So it does not make the distinction whether people is socially or economically advanced or not. So it gives chance for every people in the country, whether irrespective of socially and economically stronger, irrespective of caste, creed, sex, and all. So the participation in elections stimulates a stronger participation and interest in other political values. So the compulsory voting also encourages voters to research and know about their candidates in depth. Since they are voting for their candidates, they may take more interest and also will be much more excited into the nature of politicians. So instead of simply going and voting in the elections, they will also bring awareness in politics. So there will also be increased in voting participation, which stimulates a stronger voter participation. And implementation of compulsory voting decreases the not to vote policy, which is very important aspect to decrease and to eradicate the corruption in our society. So there is the role of money will also be ultimately decreased in this. And no other leader or any candidate will need the money to rule the people to cast their vote. So let me conclude this. So if you go through any concept, just like any other concept, the compulsory voting has both its advantages and disadvantages. So as mentioned above, compulsory voting has direct link between the democracy. So which it's because we are directly determining the leader and casting our vote to whom the candidate we want to represent. But the question arises whether voting is compelled, then how it is democracy? So my own hypothesis to this query is the voting is the main fundamental concept of democracy. So one can deny their rights if the vote if any right is made for compulsion as a bad cause, but one should comply their exercise if it's for welfare of the people. The welfare of the democracy, the ultimate meaning and ultimate goal of democracy is the welfare of the people. So thank you for KSLU for giving this wonderful opportunity, and thank you for Chidanand Reddy Patel, sir. Thank you very much.
Thank you. Up next, we have Ms. Poonima Kurlikeri, Assistant Professor, JSS Sakri Law College, Hubballi, on the topic, Impact of Media on Elections and Analysis. We'll move on to the next presenter, sir.
Yeah.
Up next, we have Professor Dr. N. Dashrath, Professor and Dean, Faculty of Law, Bangalore University, Bengaluru, and Dr. Shobha Rani M., Assistant Professor of Law, Soundarya College of Law, Bengaluru, on the topic, Participation of Women in Elections for Meaningful Democracy, Legal Issues and Challenges.
Yes.
A very good afternoon to one and all. Especially good afternoon to Dr. C.S. Patil, sir, Chairman for the National Webinar, and my co-paper presenters. Today I am presenting a joint paper authored by Professor Dr. N. Dashrath, Dean, Faculty of Law, and myself, Dr. Shobha Rani, Assistant Professor, Soundarya College of Law, on the topic, Participation of Women in Elections for Meaningful Democracy, Legal Issues and Challenges. Women has a special place in society. She is worshipped as mother, first teacher in family, and is known for holding multiple roles such as the role of mother-in-law, daughter-in-law, etc. There is a common saying in society that social work is a nobler than politics. Hence, honest persons, particularly women, must keep away from the usually marshy politic fields if one has to preserve one's own image. Due to this perception, many women, though capable to play an active role in politics, have remained far away from politics. It is to be noted that for all the social problems, such as questions of reforms in education for eradicating child marriages, introducing reforms for the purpose of addressing atrocities against women through legislation and statutes, are the questions for introducing a common civil code requires political decisions, though the political power in society provided there is participation and representation of women to address the said social problems. We, the authors of this article, draw the attention of the readers that though most of the women participated in our freedom movement against the British, yet very few women members, that is 14 members, were elected to the first Lok Sabha elections in 1952. Further, it is to be noted that at the time of framing the Constitution by the Constituent Assembly under the leadership and chairmanship of Dr. B.R. Ambedkar for drafting the Indian Constitution, there was only a single woman member, namely Begum Rasool. However, at the time of concluding the Constituent Assembly deliberations, there were 7 women members who were intellectuals and great thinkers on meaningful democracy. Women in our country, before and after independence, have participated and played a significant role in launching movements in order to find solutions for social problems. Further, women in a way have contributed their share of participation in electoral process by winning elections to Lok Sabha and state legislative assemblies. There are many anti-discriminatory legislations passed by Parliament and state assemblies such issues and test upon to what extent the anti-discriminatory laws for women helped in improving for effective electoral participation of women. Further, we also like to test upon to what extent the social movements launched by women helped for electoral participation by contesting elections to Lok Sabha and state assemblies. And also like to address these issues by adopting methodology of research and by analyzing the data available in regard to elections of women to Lok Sabha and some state legislative assemblies from the period 1952 to 2019, and that of the data available in regard to the recently concluded 5 state assembly elections in the year 2022. When we look into the concept of political participation of women, in 1990, the United Nations Economic and Social Council endorsed a target of 30% women in decision-making positions in the world by 1995. This target was far from being met by 1995. Only 10% of the world's parliamentarians were women. Today, around 16% of the world parliamentarians are women, short till of 15% of the target. The social reforms in our country, those stressed for education of women for their enlightenment. However, the reformists wanted educated women should play the traditional role in family by taking care of in-laws, husband, and children. They felt education for women was not for participation in elections. When we look into the analysis of data, we the authors has given the statistics relating to data and women elected to Lok Sabha along with its percentage from the period 1952 to 2019, which is referred in table in the article. When we look into the plain analysis of data, which is available in table 1, we the authors submit that during the first 3 Lok Sabha elections, that is 1952, 1957 and 1962, there is a marginal increase. While thereafter the following 3 Lok Sabha elections, that is 1967, 1971 and 1977, there is a sharp decrease in women elected member to Lok Sabha. During all these Lok Sabha elections, the first women become the Prime Minister of India, namely Mrs. Indira Gandhi. The number of women elected members in 1980 Lok Sabha elections had a marginal increase. Again, at that time also, Mrs. Indira Gandhi was the Prime Minister. To put in a nutshell, Prime Minister Indira Gandhi did not make any impact of women participation in election to Lok Sabha, though there were number of men and women movements protesting against the imposition of emergency and curtailing the citizens for access to justice to 42nd Amendment. However, in 1984 elections in Lok Sabha, there was a sharp increase in women members elected to Lok Sabha, that is 44 members, when Rajiv Gandhi became the first Prime Minister. However, Rajiv Gandhi became the Prime Minister. However, point to be noted is from the period 2004 to 2014, during the regime of Dr. Manmohan Singh Prime Ministership, there is a sharp increase of women members elected to Lok Sabha. At that time, Mrs. Sonia Gandhi was the Congress president. Of course, there was no social movements by men or women in the country. It is happy to note that during the period 2014 to 2021, in the regime of Prime Minister Sri Narendra Modi, the women elected members to Lok Sabha increased from 62 to 78. However, during this period, there were no social movements of men or women in India except that of the farmers' movement in the borders of New Delhi against the farm laws. We, the authors, analyzed the data mentioned in table number in pertaining to women elected to different state legislative assemblies by taking sample of Maharashtra, a few states, namely Andhra Pradesh, Maharashtra, Telangana, Karnataka, Kerala, and Goa. All these states are having satisfactory level of literacy elected members to state assembly is satisfactory. But the same is not true for the state of Tamil Nadu, since the percentage of elected members in the said state assembly is low. While in state of Kerala, which is known for 10% literacy, the elected members to state assembly is satisfactory, but not so much. While we compare the data with low literacy and more social and economic backward states such as Rajasthan, Madhya Pradesh, Bihar, Haryana, Uttar Pradesh, we respectfully submit that these low literate and backward states have showed an excellent representation of women participation in elections to state assemblies, since women elected members in these states is quite satisfactory. Point to be noted is in the state of Haryana and Rajasthan, educational qualifications are prescribed for both men and women members contesting in elections to panchayat bodies, and also different qualifications were provided for SC, ST, and other backward classes when compared to the general category. The percentage of women elected members is satisfactory in state assemblies without prescribing any educational qualifications. And therefore, the authors respectfully submit that the issue number 1 framed as social movements and their nexus to participation of women in elections, and issue number 4 framed as prescribing educational qualifications for participation in elections, both men and women, has no nexus to the number and percentage of women elected members to Lok Sabha and state assemblies respectively. So further, we say that it has the hypothesis number 1 and 2 has been proved negative. We also framed issue number 2 as, in short, issue number 2 as eliminating discriminatory practices by law against women and its nexus to women participation in elections, and issue number 4 as the qualification as means to contest in elections. We submit that though the Parliament of India has enacted legislations for eliminating discrimination against women, such as law for abolishing triple talaq, law for providing proportionary status to women, raising marriage age for female from 18 years to 21 years, have no much impact bearing on women participation and women members elected to Lok Sabha and state assemblies. When we analyze table number 4, data showing women elected members to state assemblies, which recently went to polls for in 2022 in the states of Goa, Manipur, Punjab, Uttarakhand, and Uttar Pradesh, by plain analysis of data, out of 561 women members contesting to assembly election, only 47 women members got elected to UP State Assembly. While in Punjab, 93 women contested, only 13 got elected to Punjab State Assembly. While in state of Uttarakhand, 63 women contested, only 8 women members got elected to Uttarakhand State Assembly. And an important point to be noted here is, though Indian National Congress Party allowed 148 seats for women, but only 1 women member got elected to recently concluded UP State Assembly elections. Therefore, we respectfully submit the hypothesis number 3 framed is proved to be negative, because anti-discriminatory laws passed by the Parliament did not have any impact on participation of women in elections to state assemblies. And we also frame issue number 3 as ensuring binding force for the promises made in election manifestos by national parties, and issue number 5 as self-initiative norms by political parties' constitutions for representation of women in elections. In this regard, we, the authors, respectfully submit that surely ensuring binding force for promises in election manifestos for representation of women in Lok Sabha and state assemblies will bear an impact for improving women participation in elections. Election Commission of India guidelines in this regard are to be complied with. And also, the national political parties' constitution by themselves frame some norms for the representation of women in elections, then there will be quite improvement in participation of women in elections. Reference also is made to the judgments of Supreme Court in case of Vivijay Kumar Pandey versus Union of India in regard to election manifesto, and also reference is made in regard to the judgment delivered by Supreme Court holding triple talaq unconstitutional in case of Shaira Banu versus Union of India, and also providing co-partnership status for women in joint family property in case of Vinita Sharma versus Rakesh Sharma. Finally, the challenges of overcoming the participation of women in elections, such as violence in elections, character assassination of women contesting for election, use of money power, muscle power be addressed by strict implementation of laws. Finally, we'd like to conclude. We have seen lone women person becoming chief ministers and lone women becoming head of the government and head of the state, namely Ms. Indira Gandhi as Prime Minister and Ms. Pratibha Singh Patil as President of India, while we saw Mayawati as the Chief Minister of Uttar Pradesh, Mamata Banerjee as Chief Minister of West Bengal, Uma Bharati as Chief Minister of Madhya Pradesh, and Jayalalitha as Chief Minister for Tamil Nadu. This in a way does not favor for meaningful democracy in regard to participation of women in elections. Finally, we have provided few suggestions. Suggestion number 1, the best way for the participation and representation of women in elections would be by ensuring for framing norms in the constitution of nationally recognized political parties in India. Suggestion number 2, there has to be greater awareness for peaceful social movements by women for the political consciousness without any bias to nationalize recognized political parties. Suggestion number 3, state funding of elections be tried an experimental basis for encouraging women participation and contesting elections to such women who do not have criminal record and have good record of achievement and experience in societal life. Thank you for providing me this opportunity, especially to Chairman Sir and also my guide, Professor Dr. Darshit Sir. Thank you.
Thank you, ma'am. Up next, we have Sameer Kagad, first year BA LLB Honors, KSLU's Law School, Hubballi, on the topic electoral malpractices.
A very good afternoon, everyone. I am Sameer Kagad, student, KSLU Law School, Hubballi. Today, I would like to present on the topic electoral malpractices. India is the largest democracy in the world. Democracy means government of the people, by the people, and for the people. As defined by the Indian Constitution, India has a parliamentary system with power distributed between the central government and the states. So, people's participation in governance is very important. In India, people participate in government making through elections. Electoral frauds and malpractices involving money, muscle, caste, religion, etc. present tangible yet distinct threats to the election process. India has numerous elections that are conducted every year. It starts from the state election to the district election and even extends to the panchayat elections. In 1950, Election Commission of India was established. This constitutional body is responsible for conducting free and fair elections in the country. Today itself, Shri Rajiv Kumar got appointed as the Chief Election Commissioner with effect from 15th May 2022. It is a very unique agency in its mandate, powers, and functions. It is one of the few agencies in the country that is wholly independent, and its only constitutional duty is to conduct election in a fair and impartial manner. Ever since Election Commission came into existence, it has made the election process a lot easier for the people of the nation. Some of the notable achievements are the introduction of electronic voting machine, voter ID cards, nota, etc. Also, the robust and bold implementation of the Model Code of Conduct during the election of 2009 was another great milestone to know. What are the malpractices that are taking place? An Indian as an individual is a good individual, but Indians collectively often portray a herd instinct, a feudal submissiveness to the leaders along caste and communal lines. Often, their actions are at variance with their professed convictions. The average Indian's attitude towards caste, religion, and politics exhibits resigned hypocrisy and self-serving manipulativeness. Because for him, ultimately, politics is an extension of caste or religion. The result, stunt development fraught with the danger of further divisions. The increasing cost of elections led to unethical, illegal, and even mafia-provided electoral funding, corruption, criminalization, and black money generation in various forms. This is a major money and muscle power problem. Politicians tend to indulge in illegal activities to earn a lot of black money so that they can use it during election and win. They also get funded by mafia organizations for exchange of future support, and this leads to increasing criminalization. The increased cost of elections has also led to corruption in the system. Caste and communal hatred. Campaigns are crafted to create tensions between the communities, to incite the feeling of hatred and on the basis of caste, community, religion, race, language, etc. These attract disqualification at present, but effective implementation of law is lacking. This deserves the highest degree of attention. The Election Commission recommends that any election campaigning on the basis of caste or religion and any attempt to spread caste and communal hatred during elections should be punishable with mandatory imprisonment. If such acts are done at the instance of the candidate or by his election agents, this would be punishable with disqualification. Booth capturing and rigging, that is, use of muscle power, also mentioned by Professor K.C. Sunny sir. The inaccuracy in electoral rolls and the voter identity is leading to rigging and denial of voting rights to a large number of citizens. The increasing number of contestants with serious criminal antecedents is leading to criminalization of electoral process. As pointed out by Professor Vivijay Kumar sir regarding the recent stats, that about 29% of our elected representatives have a criminal history, that too not of any small crimes, but crimes including rape, sexual assault, etc. Those such heinous crimes, and yet they get elected. Abuse of money power, also pointed out by Professor P. Ishwar Bhatt sir. Abuse of money power is one of the most critical problems in the matter of electoral reforms. It is the hard reality for contesting an election, one needs a large amount of money. The limit of expenditure prescribed are meaningless and almost never adhered to. As a result, it becomes difficult for the good and honest people to enter legislatures. No matter how we look at it, citizens are directly affected because apart from compromised governance, the huge money spent on elections pushes up the cost of everything in the nation. Electoral compulsions for funds become the foundation of the whole supreme structure of corruption. So what can be the solutions and what are the actions taken against malpractices? The question of bringing about the comprehensive changes in the election laws and electoral processes have been receiving the attentions at various levels. The most recent official exercise in this regard have been the Goswami Committee on Electoral Reforms 1990, the Indrajit Gupta Committee on State Funding of Election 1998, the Law Commission's report on reform of the electoral laws in 1999, and many more. On the question of booth capturing and rigging and intimidation of the voters, the Commission recommended under Section 58 of the Representation of Peoples Act 1951, the Election Commission should be authorized to take a decision regarding both booth capturing on the report of returning officers, observers, or citizens. Also, the Commission should be empowered to countermand the election and order a fresh election, or to declare earlier poll to be void and order a re-poll in the constituency. Second, Election Commission should consider the use of tamper-proof video and other electronic surveillance in the sensitive polling stations or constituencies. Any election campaigning on the basis of caste or religion and any attempt to spread caste and communal hatred during elections should be punishable with mandatory imprisonment. The Commission recommends that the political parties as well as the individual candidates be made subject to a proper statutory audit of the amount they spend. These accounts should be monitored through a system of checking and cross-checking through the income tax returns filed by the candidates, parties, and their well-wishers. At the end of the election, each candidate should submit an audited statement of their expenses under specific heads. Now let us see some of the provisions of the Constitution regarding this topic. To achieve these objectives, Article 326 of the Constitution enfranchises for all the adult citizens and empowers them to vote at the elections to the Lok Sabha and the state assemblies. Article 324 vests the superintendent's direction and control of the preparation of electoral rolls and conduct of elections in an independent election commission. Under Articles 243K and 243ZA, elections to local bodies, panchayats and municipalities are the responsibility of State Election Commission. At last, I would like to conclude by saying elections play a major role in any democracy. Around 912 million Indians eligible to vote and pick their representatives is a majestic and unparalleled exercise of democracy, which rightly evokes the admiration and respect of the rest of the world. Elections should not be so expensive that only those with financial power can hope to win. Such high-cost elections can never lead to a healthy democracy. The great socialist leader Ram Mohan Lohia came up with the slogan, "One note, one vote." The Representation of People's Act has laid down a strict code of electoral conduct to ensure that no extra influence is brought to bear on the voters in the free exercise of his franchise, and also gives every Indian an equal opportunity to contest election if he or she wishes to. The use of money, muscle, caste, religion has destroyed the true intention of elections. A poor election involving these will lead to biased and unprofessional leaders, which will stifle the growth and choke the progress of a nation. We need to combat this to secure a free and fair elections. Educated people must realize their responsibility, and government should also focus on awareing and educating illiterates about elections. Thus, the objectives can be achieved. Thank you.
Thank you, Samir. Up next, we have Srimati Vani C, Assistant Professor of Sharada Vilas Law College, KM Puram, Mysuru, on the topic, the new vista in vital role of nota in electoral reforms.
No, one is not there. She was there, but now she is not online. Now she has come back.
Is that right? Yes.
Hello. It was a technical issue, sir. I'm so sorry.
No issues. You can rotate your phone. Yeah, now it is all right.
Okay, sir. Good evening, everyone, respected chairperson and my fellow participant. Today, I'm going to present a paper on the new vista and vital role of nota in electoral reforms. Giving teeth to tiger, the right to reject as a part and parcel of the right to vote, which is a fundamental right, gives rise to the new concept called a nota. It is also based on 170th Law Commission recommendation reported in the year of 1999 as a negative right. None of the above, that is nota, introduced in India, was an option to the voters in the most of the election since 2009. The right to vote is nothing but the expression of the will of the voter, like the nota is an expression not to vote for a particular party or a person. So at the same time, in India, election that need to and are to take reformative steps to enhance the sanctity of the elections by way of contact. As a result of this, Election Commission of India introducing a provision of nota, none of the above. We all know that right to vote is a fundamental right enshrined under the shelter of Article 21. When we look into the right to vote deeply, the another part of this shows the right to reject. Parallelly to look to the right to vote deeply another part of this shows right to reject, and parallelly in the right to elect, that finally leads to right to recall. So there's the three important things we have. That first one is a right to reject, second thing is that right to elect, and also third one is that right to recall. Nota not only gives a right to reject, but also avoids a proxy voting by attracting the think tanks to booth and cast their votes, rejecting all the above candidates' right to vote, right to reject, and right to recall. These are all a right runs together with a great bonding of providing the clear-cut right to vote as a byproduct of free and fair election using a formative methods like Nota in India. The Nota is a reformative tool I already mentioned. So in the current era, brings back these persons to mainstream of voting process by increasing the percentage of voting, in which another way to decreasing the malfunctioning of the whole process of voting and election process in India. So then next, I want to give information regarding that evolution of Nota. It is in the year of 1976, the whole world is surprised when the Isla Vista Advisory Council passed a resolution to put forward the Nota choice in the official electoral ballot in the country of Santa Barbara and also California and USA in the year of 1976. Not only these particular states, so that is France, Belgium, Brazil, Greece, Ukraine. So these states is also introduced this particular Nota, but they are also introduced that this particular right in the name of Nota only, but Finland and Switzerland using a different name, that is a blank vote or write in. So then next important thing is that we come to the Indian perspective, that is, so in India in the year of 1999, the Law Commission in its 178th report put forth a proposal to the use of negative voting to reject all the candidates. Its voters found them undeserved and unsuitable. This negative voting to reject is nothing but Nota. It is a part of alternative method of election under the James Langdo as a Chief Election Commissioner, first in 2001 and then 2004. T.S. Krishnamurthy, the Election Commission of India, supported the similar introduction of this Nota. So the similar introduction of this particular Nota under the election reforms. So the most important thing we have to understand regarding the Nota, that is the People's Union for Civil Liberties, that is a PUCL, so versus Union of India. That was the landmark judgment and also the milestone in related with the Nota, because the Supreme Court is given a direction to the Election Commission of India in 2013 that Nota button should be included in the EVM machine. Because of what? Because the person who is going to vote, so for the undeserved and also unsuitable candidate, and he have a right to expression under Article 19, clause 1, subclause A of the Indian Constitution. And at the same time, Article 14 is also giving a classification regarding that. So then how we having the right to vote? Like that only, we have all the right to reject the vote also. So there is an expression, and we have Article 14, Article 19, Article 19, that is under the Indian Constitution, and also Article 21, we have a life and personal liberty. So then that is also introduced, that is also pronounced under this particular Supreme Court judgment. So then move on to the next important thing is that significant and characteristics. So significance and characteristics. Before that, I'm going to be discussing about the significant and characteristics. I want to give some of the landmark decision is taken by the Election Commission of India. So in the year of 2013, and the Election Commission give a clarification. Then the next important thing is that in 2014, 2014, that Rajya Sabha is also having the introduction of this particular nota, but at the same time, the Supreme Court in the year of 2018 has scrapped nota option in Rajya Sabha election. So now that Rajya Sabha election is not having the option of nota. Next, in 2015, Election Commission of India announced the symbol for nota. So then we had a symbol of nota. Now I think you know how that symbol is appear in this particular EVM machine. So that is designed by the National Institute of Design. So that is in Ahmedabad. So that is one of the important landmark decision is taken by the Election Commission after this judgment is given by a PUCL case. So the next important thing is that significance and characteristics of the nota. Before we are going to understand this particular nota, first we have to understand what are the characteristics and also significance we have. So the first and foremost thing is that nota is considered as a protest. So then why that nota it should be considered as a protest here? Because we have two types of protest. One is the short time protest and also the long time protest. Like that only, the nota is also one type of protest. How? So against the corruption, against the corruption, and also to increasing the empowerment, and at the same time to eradicate the criminal background or unsuitable, undesirable candidates under the election also. That's what I am mentioning that. So under the election, nota should be considered as a tool for the protest. That is the first thing. And the second important thing is that is a concept of nota. Apart from finding its existence in EVM, it is to be finding out that it is a political significance as a tool for the greater social as well as reformative changes. Yes, exactly. So then that the nota is always having the political and sociological reformative changes under this Indian election process also. I already mentioned a particular point, that is that women empowerment. How it is women empowerment? In some particular states, they use that particular nota. So till the women candidate is announced by the Election Commission of that particular constituency. So yes, exactly. This is an indirect way of women empowerment through nota. So because that women are not ready to elect the men candidate in that particular constituency, but the Election Commission have to take the proper necessary steps to put a women candidate to that particular constituency also. So that's what it is also a tool to use to women empowerment, and also that women have to participate more under the election process in India. And next thing is that in some states it is not simultaneously would foster that sanctity of the election process, and eventually compelling parties to filing better candidates, thereby improving the current scenario. So in the current scenario, then so many people are used that muscle power, and also that is caste and also religion on that particular basis. So then we need a free and fair election. The nota is also one of the tool we can utilize. And also then one of the madam has told me that is a compulsory voting. So for that compulsory voting, that the nota is also supporting, and also the nota is always considered as a tool to increasing the think tank to the booth level, and also that is the booth, they have to come and put and cast their vote because that nota button is there, and also we can reject the undesirable, and also that is that person is not suits to that particular post. So next important thing is that what are the constitutional importance in related with nota? Then I already mentioned Article 14 and Article 19. So Article 19, Clause 1, Subclause A of the Indian Constitution, and including Article 21. So Article 14 speaks about that equality. So then how this nota is connected with Article 14? Article 14, then we are always talking about that classifications, right? So then Article 14 speaks about the classification. Exactly, that nota is also one type of classification. How it is considered as a classification here? Then we have a right to vote. At the same same time, so right not to vote. So that is another classification we have. So then, these particular classifications should be treated equally. So then, the person is not having that intention to elect that particular person, that the constitution must give an opportunity to reject that particular person also. That's what that classification should be made on the basis of this Article 14 only. So that is Article 14. So then we have to come to the next important thing, is it Article 19. So Article 19, what is that? Clause 1, Clause A, he speaks about that speech and expression. So then right to vote, then yes, exactly, this is an expression of each and every person. So under the expression, it is not only vote, so that person is going to reject that particular person and also not to vote. So that is also an expression. That is also an expression. So both the expression has to be treated equally, and that both the expression should have a constitutional validity. So that's what nota is most important. So regarding according to the Indian Constitution. And again, Article 21, I'm giving information regarding Article 21 also, life and personal liberty. So life and personal liberty, then we are talking about that life and personal liberty, that is my personal liberty. Then who is going to give, or what is it, compelling you should, what is that, put a vote to this particular political party, this particular political person? No, I don't want. So then I want to, what is that? So I want to reject that particular candidate. So then I don't have an option. So that's what I'm not going to, what is that? I am not going to cast my vote. So that's what Article 21 is also my personal liberty under the shelter of Article 21 and under the shelter of 14 and also 19, Clause 1 and subclause A of our Indian Constitution is having the concept of this nota also. Then what is the opinion regarding nota? I already mentioned it is a milestone judgment in PUCL case. So in the PUCL case only, then in the year of 2013, and the Supreme Court is given a direction to the Election Commission of India to introduce a nota button and nota button in the EVM machine, the EVM. So that is a very important thing. At the same time, I want to give some of the information in related with this, that nota, it is not a new concept, it is a old concept only. Then we have a concept that is under Rule 49(o) of the Conduct of Election Rule 1961. So in that particular rule also, we have an opportunity to reject that. If the person is not ready to vote that thing, and that person has to give an information to that presiding officer or a booth officer too. So I don't want to put a note, but here it is a question we have, that is a right to secrecy. That is most important thing. So right to secrecy, that is also right to secrecy. We have that secrecy, so has to be protected here. So the secrecy is not protected. Definitely it has a controversy with the 128 of Representatives Act. So then People's Representative Act 1951. So that's what. So these are all the things are connected with the nota here. And also then I want to mention in some other particular Supreme Court decisions, that is the Kuldeep Nair versus Union of India. So here also then they were talking about the Representative Act 17 subsection D of this particular Representative People Act 1951, and Supreme Court is given a instruction to that. So instance case, the made of artificial distinction between the right to vote and also freedom of vote as a species of freedom of expression. So then it is a wonderful interpretation is made by the Supreme Court of India, that is right to vote and freedom of voting as a species of freedom of expression. It is fails and this all the things is connected under this Supreme Court decision. And at the same time, Basheshwar Nath versus Income Tax Commission. So right to vote not only serves the private interest but also a public interest. So ironically, the Supreme Court refuses to read a positive right to vote as a fundamental right, but it has read a negative vote, right not to vote under Article 19, Clause 1, Subclause A of Indian Constitution. And next one is that P. Ramachandra Rao versus State of Karnataka. Here also the same thing is pronounced again by the Supreme Court of India. And in Shailesh Munnabai versus Election Commission. So here in this, it is that the nota is only applicable for adult suffrage. That means for the direct election, so not for the indirect election. So in this particular petition, so that including the nota in Rajya Sabha that was challenged, and also Supreme Court in the year of 2018, I already mentioned. So then Rajya Sabha, that nota is not applicable. That for the Rajya Sabha election, nota is not applicable because of what? Under Article 80, subclass 4, under Article 80, class 4 of Indian Constitution is also giving a option regarding this single transferable vote. So that always contrary with these particular act also. What is the performance and also that is the responses in India? Under the performance and responses in India, that is most important thing. I want to give some of the statistics. I don't want to give a theoretical things, and also I will give only the performance. In 2014, the Lok Sabha election has this was around almost 1.08% of voters choose a nota. In 2019, about 1.04% of voters so fell with none of the above option, and the highest in Assam and Bihar, that is 2.08%, and Sikkim it is 0.65% also. In 2018 Karnataka Assembly election, so it is a nominal percentage we have, that is only the 0.9% of the total votes, so that nota got in Karnataka. So then I want to conclude my topic related with nota. So then the nota played a pivotal role, and not only an assembly election but also in local body election. The nota is a first step towards optimistically achieving the long back pending bill in India, right to recall bill, to become an act which was old as a great enactment like right to recall act in America. Then right to recall and right to reject should be the fundamental right in future, like a right to election. So then at the same time, that nota, it is always giving that decriminalization of political process. So then using of nota, then I want to suggest, so then nota, yes, exactly, then it is always little bit threat to the democracy also, but at the same time, so then what we having that nota, then it is definitely increasing the political party responsibility and the politicians. So at the same time, so the think bank, so definitely will reach the booth. So this is about my presentation. So thank you so much, sir.
Thank you so much, ma'am. Up next, we have Rachana JM, 4th year BA LLB Honors, KSLU's Law School, Hubballi, on the topic Simultaneous Election, the Windfall for India.
Sir, am I audible and visible, sir?
You are audible, yes. You can.
Sir, I want to share my PPT.
Hello.
Sir, yes, sir, I'm sharing the PPT.
Yeah, you have switched off your camera.
Sir, I'm finding trouble in sharing the PPT, sir. I'll present virtually itself.
No, see, it is like this. You are co-host now. Yeah, you are co-host. You can share.
Just a minute, sir. I'll check it on.
In the middle, there is one icon, screen share. Share screen. Okay.
Yes, sir.
You have to use that. Right at the middle. You are not seeing that icon? Yeah, now it came. Yes, you can start.
Is the screen visible, sir?
Yes.
Okay, sir. Elections are polarizing events which have accentuated casteism, communalism, corruption, and crony capitalism. If the country is perpetually on the election mode, there is no respite from these evils, and holding simultaneous election would certainly help in this context, opines Dr. S.Y. Qureshi, former Chief Election Commissioner of India. Good evening, everyone. I am Rachana Jayam, here to present on the topic Simultaneous Election, the Windfall for India. So within the short span of 9 minutes given, I'll be giving the bird eye view on the concept of simultaneous election, its meaning and its history in India, and I'll be jumping towards the core topic of my research topic, that is simultaneous election, the windfall for India, by analyzing the advantages of the simultaneous election over frequent election. At last, I'll be concluding the concept. So now let me introduce the concept for you. The one nation eloquence seems to be a keystone for all new initiative of Indian government. The goods of service tax came out as a one nation, one tax idea. In the field of education, there come the education policy, that is one nation, one curriculum idea, and one nation, one ration card constraints. Likewise, the notion of one nation, one election is the call for the simultaneous elections to the Lok Sabha and all to the other state legislatures. So now let me explain the concept of meaning and definition of simultaneous election. If the question arises, what actually is the simultaneous election? So for this, I'm taking the reference of para 2.6 of Niti Aayog report by Bibik Debroy and Kishore Desai. Their article titled Analysis of a Simultaneous Election, the what, why, and how. It defines simultaneous election as it implies that election to all the three tiers of constitutional institutions taking place in a synchronized and coordinated fashion. So what this effectually means is that a voter casts his vote for for electing member for all the terms of government on a single day. Here, I think third tier should be excluded because we know the reason. There are more panchayats and municipalities. So it becomes impracticable to apply this. So it only applies for those two institutions. And now I'll be taking the reference of Law Commission of India report of 2018 on simultaneous election. So in the para 1.4 of page 2, they define simultaneous election as this. They make sure that simultaneous elections would not mean that voting across the country for the House of People and all the state assemblies takes place on the single day. They may take up in the phases in the vast country like India. And if simultaneous elections are held, the voters in a particular constituency would vote for the state assembly and Lok Sabha on the same day. So this is about the definitions. Now let me deal with the history or simultaneous election in other countries and the history of simultaneous election in India. See, simultaneous election one or the other form exist in various parts of the world. Countries like Philippines, Brazil, Bolivia, Colombia, Costa Rica, and Ghana, Hindra. So all these having the presidential form of government have simultaneous election, and also various countries like Indonesia, Sweden, Germany, Spain, South Africa, they also have simultaneous elections going on in their countries. So the question arises whether the simultaneous election in India is a new concept. And I say no, because the concept of simultaneous election is in fact not new to the country, because post adoption of the constitution, that is the elections to the Lok Sabha and all states legislative assemblies were held simultaneously between the year 1951 to 1967. But due to the premature dissolution of some legislative assemblies in 1968 and 1969, this cycle of simultaneous election got disrupted. So now, see, there are recommendation on the conduction of simultaneous election in India. It may be by the first annual report for the Election Commission of India 1983 and 170th report of Law Commission of India Reforms of Electoral Laws 1999 and report of National Commission to Review the Working of the Constitution 2002 and 255th Law Commission report in the year 2015-2018 Niti Ayoga discussion paper, and also 79th report of Parliamentary Standing Committee in the year 2015, even presidential address by Sir Pranab Mukherjee, and also recently Prime Minister address by Narendra Modi ji, they have recommended for the conduction of simultaneous election in India. So the question arises, why? Is there any advantage or whether it's the windfall for India? So I'll be discussing this concept by analyzing the advantages of simultaneous election over frequent election. So let me, now I'm hopping towards the core concept of my research topic, that is simultaneous election, the windfall to India, because there are many advantages. Let me tell you which are they. The first one is voter turnout is considered to be the hallmark of representative democracy. We know that, but as a study undertaken by Mr. Kaba Nikolne, he is the Montreal-based professor at Concordia University who is studying Indian election. He draws his conclusion that separate election in India prevents more people from participating in the democratic process. And voter turnout in national election will be higher in those states where state elections are held simultaneously. Isn't it the windfall for India? Yes, it is. Now let me take the help of second advantage, that is frequent election impacts on the development programs and governance due to the imposition of model code conduct by the Election Commission. And yes, see, the thing is, we have this concept of model code of conduct. This imposition puts on the hold of the entire development programs and activities of union and state government in the poll-bound state. That is, if elections are taking place, this come into picture and all development programs are put to halt. And these development programs are hit in every year for about 1/3 of the entire time available for implementing such programs. So it affects the normal governments, and frequent elections lead to the imposition of these model code of conduct for a prolonged period of time. So what happens, this is undesirable, and switching to the simultaneous election from the frequent elections, it becomes the windfall for India as a corrective measure. So for further information regarding this, I suggest to visit page number 9 of 36 of the discussion paper by Niti Aayog. So the third advantage is that frequent election and engages security force for significantly prolonged period of time. See, by analyzing the page number 28 to 30 of the article titled India Oaths the General Election 2014, which is published by the Election Commission of India. In this, the election to the 16th Lok Sabha, ECI deployed 1,349 companies of Central Armed Police Force. So if 2 to 5 state assemblies goes to the poll for every 6 months, then the internal security system gets hampered. So as a corrective measure for this, simultaneous election will become the windfall for India. We can now take the example of the teachers who are allotted for these election duties. So the core duty of them is to impart education, but they are going for these election duties now and then their core duty gets hampered. So for corrective measures also, simultaneous election becomes the windfall for India. So now let me take the advantage of fourth advantage, that is frequent elections disrupt normal public life and impact the functionaries of the essential service. See, holding rallies disrupt road traffics and leads to the noise pollution. Thus, the Parliamentary Standing Committee, if these simultaneous elections are held, this period of disruption would be limited to certain predetermined period of the time. So for this, as a corrective measure, simultaneous election will be the windfall for India. So now let me take the help of the fifth advantage, that is frequent election and development program. See, Honorable Minister of Urban Development named Venkaiah Naidu, in his article titled "Breaking Out of Election" made in the Hindu newspaper, what he opines is frequent election impact the forms of government and political parties. So to win the next impending election, what they do is they concentrate on short-term politician imperatives as immediate priority. So for short-term benefiting concepts will be their immediate priority. So many development programs get postponed and they concentrate on promising individual benefits. For example, free electricity or loan waivers, etc. So by looking at this, even I can take the reference to the Supreme Court opinion in the case of Subramanian Balaji versus Government of Tamil Nadu and others. Here what happened is Supreme Court observed that these practices, it means the political parties concentrating on short-term goals to win the election instead of concentrating on the benefit measure for a public at large. These practices shakes the root of free and fair election, and therefore with the reduction in the frequency of election, such practices reduces and they can take up the measure which benefits public at the large. So isn't this make sure that the simultaneous elections becomes the benefits over this frequent election? So thus I can say that yes, simultaneous elections are the windfall for India. So let me take this sixth advantage also. See, frequent elections lead to massive expenditure of the public fund by the government. So if elections held simultaneously, then the expenditure is distributed between the government of India and the state government in the ratio 50-50 equally. So here we can curb that expenditure also. Isn't this the windfall for India? Like, yes, I can now say that simultaneous elections are the windfall for India. Also, for the implementation of these simultaneous elections, there is a need for the amendment of the Indian Constitution in Article 83, 85, 172, 174, 356, and also the Representation of People Act 1951. Few sections amendment is needed for the implementation of this simultaneous election. So by analyzing all these advantages, which I explained now, I can say that I can conclude that yes, simultaneous election is the windfall or the beneficial or the advantageous to India. So at last, let me conclude by taking this reference to the constitutional bench of Supreme Court. They have referred to this Merchant of Venice. It's the work which is written by Shakespeare. In the case, they have made note of that Merchant of Venice by Shakespeare. In this case, that is Charan Lal Sahu versus Union of India in the year 1990. What they observed is, to do a great right, after all, it's permissible sometimes to do a little wrong. So by taking this reference, what I'm emphasizing here is If the idea of simultaneous election is looked in a broader perspective, it will be seen that it's for the larger public good and the welfare of the country. If it is seen from the bleak view, it may have, we can find out many disadvantages. I know this is implementation takes time, and also there are many recommendations, suggestions, and also some compromises or some options have been mentioned in the Law Commission report. But what I finally conclude is that yes, simultaneous elections are the windfall for India over this frequent election. And thank you. Thanks for this opportunity.
Thank you so much, Rachna. Up next, we have M.S. Benjamin, Associate Professor, Department of Studies in Law, University of Mysuru, and Sara Magaldane, 8th semester BA LLB, JSS Law College, Mysuru, on the topic Judicial Intervention with the Electoral System and Analysis.
A very good evening to one and all. I'm Sarah, presenting a joint paper with Dr. M.S. Benjamin entitled Judicial Intervention with the Electoral System and Analysis. So India being the largest democracy in the world, and the Constitution provides for the establishment of the Election Commission of India. The Commission supervises, controls, directs and conducts the elections to the Parliament, the state legislature, the office of the President and the Vice President. India's electoral system is a paradigm for many countries because of its ability to conduct elections in a free and a fair manner. India holds the general elections regularly with the participation of the largest citizens of the world. This is possible because of the India's constitution that confers the vast powers on the Election Commission of India. The Election Commission has proved its integrity in the election process. However, there are challenges and issues that the electoral system has faced in recent years, and the citizens, more particularly, are reluctant to participate in the election process because of the loss of their trust and confidence to participate in the election process. Therefore, on several occasions, electoral reform has kindled the attention of the Parliament, the government, media, and the civil society. Election Commission and the Judiciary. The Election Commission, no doubt, has attempted to remove the glaring lacuna in law, but its power is limited to the parliamentary enactment. Nonetheless, today the assemblies and the parliament's election is influenced by extraneous factors such as money power, casteism, government machinery misuse, distribution of freebies, criminalization of politics, and such other things. Parliament is not willing to confer much more power on the Election Commission for the better implementation of the law. Significantly, however, is the Supreme Court intervention. The court plays a vital role in strengthening the election institution to interpret and construct the election laws. The Constitution of India deals with the issues of elections. It provides for the establishment of the Election Commission and the appointment of the Chief Election Commissioner and such other commissioners for the superintendence, direction, and control of all elections to the Parliament, legislative assemblies, and President's office and the Vice President. Under the Constitution, no person is ineligible for the inclusion in the electoral roll on the grounds of religion, race, caste, or sex. And the Parliament and the legislative assemblies of the state is based on adult suffrage. With the Article 329 Clause B allows that it will not come into the power of the jurisdiction of the court from the electoral matters will not come into play when the case falls under Article 191 and 193 and the whole election process is over. What are the functions of the Election Commission? The Committee on the Constant Assembly on Fundamental Rights, it opined on the independence of election, as it would be regarded as the fundamental right of every citizen. The Assembly agreed with the opinion of the committee that the question of fair elections was a matter of great importance, but it was not in favor on embodying a right to the effect in chapter of the fundamental rights. So in pursuance on the Assembly's decision, the drafting committee removed the matter from the category of fundamental rights and put it in a separate part and finally became a part of the Constitution under Part 25. The function of the Election Commission is to prepare, maintain, regularly update the electoral roll, supervise the nomination of candidates, register political parties, supervise the election commissions, including expenditure by candidates. The role of the Supreme Court with regard to the electoral process. First being the disclosure of information relating to the candidates' assets and criminal records. In a very landmark judgment in Union of India versus Association for Democratic Reforms, the petitioners for the Association of Democratic Reforms, they moved to the Supreme Court for a direction to implement the recommendation by the Law Commission in its 178th report. And the Supreme Court directed the Election Commission to issue a notification which made it compulsory for the candidates who contest the election to disclose the information pertaining to their education, assets, liabilities, and criminal antecedents for the voters. But the Parliament amended the Representation of the People Act and abrogated the court's judgment and the Election Commission's notification as well. The Association for Democratic Reforms again challenged this and said that the Representation of People's Act as being violation of citizens' fundamental right, that is Article 19(1)(a). The Supreme Court held that the Parliament had no such legislative competence to direct the state or its instrumentality to disobey the court's law. And the Parliament cannot declare that the law declared by the Supreme Court is not binding. Therefore, it upheld this, and the Election Commission had to issue a fresh notification for the implementation of the Supreme Court judgment. Now, with regard to the disqualification of convicts from being the members of the legislature, in Basant Kumar Chowdhury versus Union of India, the Supreme Court held that the members of the Parliament and the state legislative bodies who were convicted of a crime or were sentenced for jail were disqualified from contesting the elections or holding on an elected seat. But the Representation of the People's Act, Section 8, Clause 4, protects or gives a blanket protection for the convicted members of the Parliament or the assemblies against disqualification, and they can file an appeal against the conviction. The petitioners challenged this section, and it was held by the Supreme Court that this section is ultra vires to the Constitution. The expressive dissent against the contesting candidates. In a celebrated case of People's Union for Civil Liberties versus Union of India, also called as Nota's case, the Supreme Court directed the Election Commission to include Nota, being none of the above, option in the election process. The rule provides for the voter a choice to express their dissent against the contesting candidates. And the same provision has its limitation that the nota votes will not be taken into consideration to nullify the candidate's victory. Effect of non-disclosure of details of criminal cases against the candidate. In Krishna Murthy versus Shiv Kumar and others, the State Election Commission of Tamil Nadu issued a notification that stipulated that every candidate who desired to contest the election was required to furnish complete information about the pendency of criminal cases at the time of filing of its nomination paper. The question was whether the non-disclosure of criminal attendance would tantamount to undue influence of a facet of corrupt practice as per Section 123, Clause 2 of the Representation of People's Act. The Supreme Court viewed and gave three major points. First being that such of the non-disclosure would impediment in the free exercise of the electoral right, and the concealment deprives the voters from the right to vote, and this would indeed lead to undue influence. The criminalization of politics. So on the issue of recommendations made by various committees, they have ignored the issue have been ignored by the government despite the support from different political parties, civil society, and the experts. Therefore, in Akul Chandra Pradhan versus Union of India, the court, while dealing with the provisions made in election law, which excluded persons with criminal background from the elections as candidates, the court held that the object was to prevent the criminalization of politics and maintain probity in elections. Now, moving on to the use of black money in the electoral process. It is well established that money plays a significant role in politics, whether in conducting or campaigning for elections. The Election Commission, in its guidelines, recognized that the concerns have been expressed in various quarters that money power is disturbing the level playing field and vitiating the purity of elections. There are not mere theoretical debates, but are actual problems afflicting the electoral process in India. Money, often from illegitimate sources, result in undistinguished bullying when used to buy muscle power, weapons, or to unduly influence voters through liquor, cash, and gifts. Using black money was best articulated by the Supreme Court in Kanwarlal Gupta versus Amarnath Chawla by stating that money is bound to play an important part in the successful prosecution of an election commission. Money supplies assets for advertising and other forms of political solicitation that increases the candidate's exposure to the public. It can also provide the means for quick and speedy communications and movements and sophisticated campaign techniques. From the above discourse, I would like to conclude that it is evident that the Supreme Court has issued various guidelines and directives to reform the present electoral system to ensure a free and fair election in the constitutional democracy. It is the legislature, the executive, and the election commission, and all the stakeholders' duty to implement the directions of the Supreme Court. Despite the honest efforts of the Supreme Court, we still find the candidates filing false affidavits, providing misleading information about the financial position, criminal records, educational qualification, using black money, criminalization of politics, seeking votes in the name of religion, race, proactive speeches by the leaders of the political party to benefit in its own candidates, false promises to fulfill religious objectivities. It is the constitutional duty of the Election Commission to take strict action against these political parties and candidates who fail to comply with the statutory provisions. The Supreme Court has played a paramount role in reforming the electoral system. Still, it can compel religion and caste-based parties to declare their commitment to constitutional values and principles. Thank you.
Thank you. Now I would kindly request our chairperson, Professor C.S. Patil, to speak a few words.
Good evening, everyone. It is so nice to be with all of you on the platform right from 10 a.m. till past 5 p.m. 12 papers are presented in this paper presentation session. We started at 2:30. We're starting with the joint paper of Professor Ramesh and Ashraya Chakrabarti, paper of Srimati Bhagyamma, Sri Pramat Adiga, Srimati Akhila Prabhu, Sri Jayakumar K.S. along with Professor Basuraju of Mysore University, Srimati Anita and Professor Ramesh. Then we had a joint paper of Dr. N. Dasharath, which was presented by Dr. Shobharani. Then we had a paper by Srimati Wani. And I have to make a special mention of four what I can say as a sort of star papers presented by the students by Mr. Mahesh Aditya of 7th semester, Samir Kagar of 2nd semester, Rachana JM of 7th semester, and Sarah Magdalene of 8th semester. In fact, it was so pleasurable for me to preside over paper presentations, which chance I got because Professor G.B. Patil excused himself at the last moment. The papers were very qualitative and the presenters were very articulate, and these are the scholarly discourses that went on in this national webinar, and it is so beautiful to see almost Every person who presented paper is an youngster, and with that, we seniors feel that there is vibrant thinking and analysis and research that is going on in the field of law. As the head of the Research Center in Democracy and Constitutional Government, I will be failing in my duty if I do not acknowledge the presence of certain of the people right from the morning. In my welcome address, I could take the names of few of the people, but so many were left out because of the jumble up in organizing all these things. We had, along with Professor Sudesh, we had Professor Nadagowda, Professor Satish Gowda, we had Dr. Mallikarjun Swamy, we had Dr. Mohan Balla, we had Dr. Dashrath, we had the senior professor S.S. Patgundi, we had Dr. S.T. Nirvani, and so many other people, and almost all of them went with us till afternoon and evening. They were all present there on the platform. The program becomes success because of participants, and it is not just the number, it is the quality presence that makes all the difference. We all began as LLB students, LLM students, and picked up these research skills and analytical skills, looking at our elders, our teachers, and gradually grew. And I feel so happy that quite a few youngsters have taken initiative to take part in this, both researchers, faculty members, and also students. And the encouragement for the organizers, for the speakers, the performance quality of the speaker will enhance depending upon the number of people present. Despite being vacation, despite being sandwiched in semester examinations, despite all those teachers being on examination duty, a constant attendance was secured, and I am beholden to everyone who was present on the platform to make this program a success. And as I was telling you in the inaugural program, all this happens because of the right guidance of our Honorable Vice Chancellor, who said you are a Center for Research in Democracy and Constitutional Government. So if not you, who has to take that? And same is the case with the message of Professor Jeevan Kumar also. So as responsible citizens of India and as a responsible institute that belongs to the state level law university, it is both a privilege and also duty on the part of us to organize these activities. And we have a debate competition and we have an essay competition that is lined up. I request we will send the links for this also, for a debate competition. You may witness that. I thank everyone who went with our center and university in coordinating this, and especially our student volunteers. Despite being in different places, they volunteered, joined us in organizing this program. I thank everyone, and with that, we call it a day. Back to you, Neelamika.
Thank you, sir. I thank our chairperson, Professor C.S. Patil, Center Head, Center for Research in Democracy and Constitutional Government, for his expertise, and also to all the speakers for today's for their par excellence. Thank you one and all, and have a great evening.
Yeah. So we adjourn. Thank you very much. Thanks everyone. Yes, sir. And meeting modern